there we will cover up. Okay, already half the portion is completed in this batch. Okay, we'll cover up in the weekend batch. Okay. We were studying regarding the Supreme Court. Okay, how many judges are there in Supreme Court?
34.
34. 33 plus 1. Let's do the revision part. Okay, in a Supreme Court, this is Supreme Court is the topmost court in India, and it was inaugurated. It was inaugurated. Inaugurated in India on which date? January 28, 1950. Commencement of the Constitution. That is the Republic Day. Okay. This is the commencement of the Constitution. Constitution came into force on this day. After 2 days, Supreme Court was inaugurated. And how many judges are there? There are 33 judges in a Supreme Court plus 1 Chief Justice of India. Mukhya Nyayadhisharu. Chief Justice of India. Okay. Chief Justice of India. Next, in an original constitution, how many judges were there? This is the present strength of Supreme Court. In Supreme Court, we are having 33 plus 1 right now. Okay. In original constitution, this one. In original constitution, how many judges were there? 7 plus 1. 8. Okay. 7 plus 1. This is the fixed position. This Chief Justice of India is the fixed position. This will be. Time to time, they will increase the strength of Supreme Court judges. Out of 145 crore people, we are having 33 plus 1 judges. As to cases, more than 5 lakh cases are pending in the Supreme Court. You got my point? Why it is pending? Why so? Because it is, the strength is less in number. All cases ಗಳು Supreme Court ನಲ್ಲಿ ಇದ್ದಾಗ they can't handle the cases at a speedy time because the strength is less. Understood? There are more than 5 lakh cases that are pending. ಅದಕ್ಕೆ ನೋಡಿ Supreme Court ನಲ್ಲಿ ಒಂದು ಕೇಸ್ ನೀವು ಫೈಲ್ ಮಾಡಿದ್ರು ಕೂಡ it takes 5 years, 10 years, 15 years, 20 years. ಜೀವನೇ ಹೋಗ್ಬಿಟ್ಟಿರುತ್ತೆ ಅಷ್ಟೊತ್ತಿಗೆ. Understood? Because the cases are more in the Supreme Court. The strength is less. ಇವ್ರುಗಳೇ judgment ನೀಡೋರು, not the other people. Okay, they will handle the cases. That's why it takes time. Okay, there are a lot of hearings will be there, lot of sessions will be there. Okay, that's why it takes huge time to get a justice in India. If any of the matter is of national importance, sudden ಆಗಿ ಆ ಕೇಸ್ ನ ತಗೊಳ್ತಾರೆ. They will discuss regarding that. Okay, ಯಾವ್ದು ಎಮರ್ಜೆನ್ಸಿ ಇರ್ತದೋ ಆ ಕೇಸ್ ಬಗ್ಗೆ, ಇಫ್ ಇಟ್ ಇಸ್ ಅ ನ್ಯಾಷನಲ್ ಇಂಪಾರ್ಟೆನ್ಸ್, ಫಸ್ಟ್ ಆ ಕೇಸ್ ಬಗ್ಗೆ ಏನು ಅಂತಂದ್ರೆ ಹಿಯರಿಂಗ್ಸ್ ಎಲ್ಲ ಆಗ್ತಾ ಇರುತ್ತೆ. ಓಕೆ, ಅಂಡ್ ದೆನ್ ಪ್ರಯಾರಿಟಿ ಬೇಸಿಸ್ ಮೇಲೆ ಅದು ಜಾಸ್ತಿ. ಓಕೆ, ಇಸ್ ದೇರ್ ಎನಿ ಡೌಟ್? ನೋ ಡೌಟ್. Okay. This Supreme Court was inaugurated on January 28, 1950, and Article 124 to 147 that deals with Supreme Court. I will send all the PDFs for you. Okay, PPTs. Next, as I told you, how many judges are there? 34 judges, 33 plus 1 judge. Now, original constitution, it was 8. That is Chief Justice and 7 were other judges. In order to appoint the Chief Justice of India, he will be appointed by whom? President. Okay. Chief Justice of India will be appointed by the President. And other judges are also appointed by the President itself. Our appointment model. Okay, and in order to become the Chief Justice of India, the senior most judge of Supreme Court will become the Chief Justice of India. Okay, senior most judge. This and High Court, 90% it is similar itself. Okay. Who is that? In order to become CJI, Chief Justice of India, out of these 33 judges, one of the senior most judge will become the Chief Justice of India. Senior most, it is not based on the age, it is based on the experience of how since from how many months or how many years he has been appointed as a judge of Supreme Court. ಎಷ್ಟು ವರ್ಷದಿಂದ ಸೇವೆ ಸಲ್ಲಿಸ್ತಾ ಇದ್ದಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಲ್ಲಿ, based on that he will be appointed as a CJI. Okay, not based on the age. What are the qualifications to become the judge? In every chapter, the qualification that starts with citizenship of India. Okay, he should be a citizen of India, he should not be a foreigner. Next, there is no minimum age to become the judge of Supreme Court, but there is a maximum age. Okay, that we will study. In order to become the judge of Supreme Court, firstly he should serve as a judge of what? High Court. Supreme Court judge avakana munche he should work as a High Court judge. For how many years?
5 years.
For 5 years. The minimum of 5 years is required to serve as a judge of High Court. Then, or if not this one, then this. He should be an advocate of a High Court for a minimum of is to 10 years. Okay. If he is working as a advocate also, if he is serving for 10 years, he is also eligible for becoming the Supreme Court judge. Okay. Or idu irlilva, this one, that is he should be a distinguished jurist in the opinion of the president. ಅಂದ್ರೆ ಸುಪ್ರಸಿದ್ಧವಾದ ಜಡ್ಜ್ ಆಗಿರ್ಬೇಕು ಯಾರ ಕಣ್ಣಲ್ಲಿ? ಪ್ರೆಸಿಡೆಂಟ್ ಅವ್ರ ಕಣ್ಣಲ್ಲಿ. ಫಸ್ಟ್ ಪ್ರಯಾರಿಟಿ ಇಸ್ ದಿಸ್ ಒನ್ ಓನ್ಲಿ. ಇಲ್ಲಿ ಯಾರು ಎಲಿಜಿಬಲ್ ಇರ್ಲಿಲ್ಲ, ಅಷ್ಟು ಕೇಸ್ ಸಾಲ್ವ್ ಮಾಡುವಂತ ಇದು ಇರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ದೇ ವಿಲ್ ಗೋ ಫಾರ್ ದಿಸ್ ಒನ್. ನೆಕ್ಸ್ಟ್ ದಿಸ್ ಒನ್ ಪ್ರಯಾರಿಟಿ ಬೇಸಿಸ್ ಮೇಲೆ. Okay, then Constitution has not prescribed a minimum age for appointment of judge of Supreme Court. It's not like 30 age, 45, 50 illa. But in practicality, whoever are the age of 55 plus, they will become the judge of Supreme Court. Practicality, it is not mentioned in the Constitution, but ಅಷ್ಟಾಗ್ತದೆ. ಯಾಕಂದ್ರೆ LLB ಮುಗಿಸಿ LLM ಮುಗಿಸ್ಬೇಕು, ಹೌದಾ? ದೆನ್ ದೇ ಶುಡ್ ಪ್ರಾಕ್ಟೀಸ್ ಆಸ್ ಎ ಅಡ್ವೊಕೇಟ್. ಹೈಕೋರ್ಟ್ ನಲ್ಲೇ 10 years ಆಗ್ಬೇಕು, ಆರ್ ಎಲ್ಸ್ ಜಡ್ಜ್ ಆಗ್ಬೇಕು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ 5 years. ಎಕ್ಸಾಮ್ಸ್ ಇರ್ತದೆ, ಓಕೆ, ಜುಡಿಷಿಯಲ್ ಸರ್ವಿಸ್ ಎಕ್ಸಾಮ್ಸ್ ಅಂತ ಹೇಳಿ. ಓಕೆ, ಅದೆಲ್ಲ ಪಾಸ್ ಆಗ್ಬೇಕು, ಜಡ್ಜ್ ಆಗ್ಬಹುದು. ದೆನ್ ಇಟ್ ಟೇಕ್ಸ್ ಮಿನಿಮಮ್ ಆಫ್ 55 ಏಜ್ ಟು ಬಿಕಮ್ ದ ಜಡ್ಜ್ ಆಫ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಓಕೆ, there is no direct exam for becoming the judge of Supreme Court. Understood? There is no kind of exam to become a judge of High Court as well. Okay, there is other kind of exam. ಅದರಿಂದ ಏನು ಅಂತಂದ್ರೆ ಪ್ರಮೋಷನ್ ಮೇಲೆ ಹೋಗ್ತಾ ಇರ್ತಾರೆ. Then oath. Who will administer the oath? ಪ್ರಮಾಣ ವಚನ ಯಾರು ಅಡಿಯಲ್ಲಿ ನೀಡ್ತಾರೆ? President. Okay, the CJI plus the 33 judges of Supreme Court, they will be given they will be administered oath by the president. President ಅವ್ರ ಮುಂದೆ ಪ್ರಮಾಣ ವಚನ ಸ್ವೀಕರಿಸಬೇಕು ಅವರು. Understood? Okay. But there is a maximum age limit. Maximum age limit is 65. It is not 60 like a government employee. Okay, it is 65. Next, tenure. As I told you, the Constitution has not fixed the tenure of judge of Supreme Court. Supreme Court nalli 5 ವರ್ಷ 10 ವರ್ಷ ಅಂತ ಹೇಳಿ they didn't give. They didn't mention the minimum age as well, but they have mentioned the maximum age. That is 65. 65 ಬಂತು, ಅವ್ರು ರಿಟೈರ್ಮೆಂಟ್ ಆದ್ರು. Okay. He holds office until he attains the age of 65. 65 age ಆಗುವವರೆಗೂ. Okay. And then he can give a resignation for whom? President. President will appoint them. President will give administer the oath for them. President ಅವ್ರಿಗೆ resignation ಕೊಡ್ಬೇಕು. Okay. And he can be removed by whom? President. Okay. He will be removed by the president. Next, that removal process. Let us see the removal process. Okay. In order to remove the judge of Supreme Court or a High Court, there is a procedure. Okay, let us see that. Okay, this is the procedure. Firstly, if there is, see how the judges will be removed, on what grounds? Based on what grounds judges can be removed? ಯಾವ ಆಧಾರದ ಮೇಲೆ, ಯಾವ ಗ್ರೌಂಡ್ಸ್ ಮೇಲೆ? Okay. Not working properly. ಇನ್ನೊಂದು misbehavior or incapacity. Misbehavior or incapacity, in every chapter you will be seeing this. In constitutional bodies chapter, in all the constitutional bodies chapter, in here also. Based on only two grounds, they can be removed. One is misbehavior or incapacity. Misbehavior means not misbehaving with a woman. Misbehavior, the definition under the constitution, it says that office of profit. Illi misbehavior anta use ಮಾಡ್ತಾರೆ. Or getting the other designation as well. ಇಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ ಆಗೋದು, ಅಲ್ಲಿ ಚೇರ್ಮನ್ ಆಗೋದು ಬೇರೆ ಕಡೆ, ಅಥವಾ MD ಆಗೋದು ಒಂದು ಕಂಪನಿಯಲ್ಲಿ. That should not be done hand in hand. No understanding? Okay, ಇಲ್ಲೊಂದು ಡೆಸಿಗ್ನೇಷನ್ ನಿಭಾಯಿಸೋದು, ಅಲ್ಲಿನೂ ಇನ್ನೊಂದು ಮಾಡೋದು. That is called as office of profit. ಅಲ್ಲಿಂದನೂ ಅವ್ರಿಗೆ ಸಂಬಳ ಬರ್ತಾ ಇರ್ತಾನೆ. Okay, that should not be done. That is called as misbehavior under the constitution. Next, incapacity. Incapacity means if the judge is not healthy, if he is of infirmity, ಅಂದ್ರೆ ಬ್ರೈನ್ ಡೆಡ್ ಆಗಿರುತ್ತೆ. ಓಕೆ, ಏನಾದ್ರೂ ಸಡನ್ ಆಗಿ ಹಾಸ್ಪಿಟಲೈಸ್ ಆಗಿ ಬ್ರೈನ್ ಡೆಡ್ ಆಗಿತ್ತು ಅಂತಂದ್ರೆ, ಅವ್ರು ನೆಕ್ಸ್ಟ್ ಸೇವೆ ಸಲ್ಲಿಸ್ಲಿಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ, he will be removed. Understood? ಯಾಕಂದ್ರೆ ಬೆಡ್ ರಿಟರ್ನ್ ಆಗದಾಗ, ಕೋಮಕ್ ಹೋದಾಗ ನೆಕ್ಸ್ಟ್ ಫ್ಯೂಚರ್ ಅಲ್ಲಿ ಅವರಿಗೆ ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ದಟ್ಸ್ ವೈ if he is not well for a temporary period, it is okay. ಅವ್ರಿಗೆ ಲೀವ್ಸ್ ಗಳು ಇರ್ತದೆ, ಅದನ್ನ ಯುಟಿಲೈಸ್ ಮಾಡ್ಕೊಳ್ತಾರೆ. ಬಟ್ ಪರ್ಮನೆಂಟ್ ಆಗಿ ಅವ್ರ ಬಾಡಿ ವರ್ಕ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಗೊತ್ತಾಯ್ತು ಅಂದ್ರೆ, he can be removed. Understood? Next, the process of removal of judges of Supreme Court or Chief Justice of India. ಏನಿದೆ process? Based on grounds of misbehavior or incapacity, misbehavior or incapacity. Okay. Firstly, what is the process? In order to remove the judge, that removal motion should be signed by 100 members of Lok Sabha. How many members are there in Lok Sabha? 543 present strength. Okay, out of 543, 100 members should sign that removal motion proposal. Starting stage adu. Okay, henge ನೀವು ಕಾಲೇಜ್ ಅಲ್ಲಿ ಇದ್ದಾಗ, I don't know whether you have done or not, ಕಾಲೇಜ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ಏನಾದ್ರೂ ಮಾಸ್ ಬಂಕ್ ಮಾಡಕ್ಕೆ ಅಥವಾ ಏನಾದ್ರು ಟ್ರಿಪ್ ಹೋಗ್ಲಿಕ್ಕೆ ಅಂತ ಹೇಳಿ ಎಲ್ಲರೂ ಫಸ್ಟ್ ಬರ್ದು ಸೈನ್ ಎಲ್ಲ ಮಾಡ್ತಿದ್ರು ನೋಡಿ, ಎಲ್ಲ ಸ್ಟೂಡೆಂಟ್ಸ್ ಗಳು. I don't know whether you have done or not. We have done that in college days. ಅದೇ ತರ ಅಪ್ರೂವಲ್ ತಗೊಳ್ಳಿಕ್ಕೆ we used to do that. Okay, ಆ ತರನೇ the same process. Okay, in Lok Sabha it should be minimum of 100 members should sign that. ನೆಕ್ಸ್ಟ್ ಸ್ಟೇಜ್ ಹೋಗ್ಲಿಕ್ಕೆ, ನೆಕ್ಸ್ಟ್ ಪ್ರಾಸೆಸ್ ನ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ. ಆರ್ ಎಲ್ಸ್ 50 members in case of Rajya Sabha. How many members are there in Rajya Sabha? Present strength 245. Out of 245, at least 50 should sign that. Okay, then that will be given for whom? Speaker or chairman. If that removal motion is signed by the Lok Sabha members, that is 100 members, they will give for whom? Speaker of Lok Sabha. If that removal motion has been started in Rajya Sabha, then they will give for chairman. Yesterday itself I have told you, who is the presiding officer of Lok Sabha? Presiding officer of Lok Sabha? Speaker. Presiding officer of Rajya Sabha? Chairman, that is vice president. Okay. Next, if the speaker or a chairman accepts, then the next procedure starts. Speaker or chairman can accept that motion or reject that motion. ಇದನ್ನಿದೆ ಅಲ್ವಾ, ರಿಮೂವಲ್ ಮೋಷನ್, ಅದು accept ಆದ್ರೂ ಮಾಡಬಹುದು, ರಿಜೆಕ್ಟ್ ಆದ್ರೂ ಮಾಡಬಹುದು. If they reject, no next further steps. If it been accepted, then the further steps will be initiated. Okay. Firstly, if it is admitted, if it is accepted, then the speaker or chairman is to constitute 3-member committees. ಅದು accept ಮಾಡಿದ್ರು ಅಂದ್ರೆ 3-member committees ನ ರಚನೆ ಮಾಡ್ತಾರೆ. In that 3-member committees, who will be there? Chief Justice of India or Judge of Supreme Court. And also Chief Justice of High Court. For every High Court, there will be Chief Justice of High Court. For India, there is one Chief Justice of India. India gobre Chief Justice. For every states, there are, for not every, there are 25 High Courts. For that, there is a Chief Justice of High Court. Okay. Then, ಇನ್ನೊಬ್ರು ಯಾರು? Distinguished jurist. ಸುಪ್ರಸಿದ್ಧವಾದ ನ್ಯಾಯಾಧೀಶರು. Okay, these are the 3 members. Okay, these 3 members will investigate whether he has done misbehavior or incapacity or not. Like a police, what they do. Okay, they will just collect all the documents. Okay, ಅವರು ಕೆಳಗಡೆ ಮತ್ತೆ ಇರ್ತಾರೆ. There will be there. All these departments will work under them. ED ಆಗಿರ್ಲಿ, CBI ಆಗಿರ್ಲಿ, ಎಲ್ಲಾರು ವರ್ಕ್ ಮಾಡ್ತಾರ. ಸುಮ್ನೆ ಇವ್ರು ಅಸೈನ್ ಮಾಡೋದು ಅಷ್ಟೇ ಅವ್ರ ಕೆಲಸ, ಇದನ್ನೆಲ್ಲ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳಿ. ಡೈರೆಕ್ಟ್ ಆಗಿ ಹೋಗಿ ಅವ್ರ ಮನೆಗೆ ಹೋಗಿ ಇವರೆಲ್ಲ ಇದನ್ನ ಮಾಡೋದಿಲ್ಲ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ದೇ ಆರ್ ದ ಮೆಂಬರ್ಸ್, ಬಟ್ ಅವ್ರ ಕೆಳಗಡೆ ಎಲ್ಲ ಬರ್ತಾರೆ. ಪೊಲೀಸ್ ಆಫೀಸರ್ಸ್ ಆಗಿರ್ಲಿ, ED ಆಗಿರ್ಲಿ, CBI ಆಗಿರ್ಲಿ, ಲೋಕಾಯುಕ್ತ, ಲೋಕಪಾಲ್, ಎವ್ರಿಬಡಿ. Okay, they will work under them. And once these 3 members give the report, in that report, if the person is guilty, if the judge is guilty ಅಂದ್ರೆ ತಪ್ಪಿತಸ್ಥ ಅಂತ ಪ್ರೂವ್ ಆಗಿತ್ತು ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಫರ್ದರ್ ಸ್ಟೆಪ್ಸ್. ಗಿಲ್ಟಿ ಅಂತ ಪ್ರೂವ್ ಆಗಿಲ್ಲ, ತಪ್ಪಿತಸ್ಥ ಅಂತ ಪ್ರೂವ್ ಆಗಿಲ್ಲ, ಇಫ್ he is innocent, then no further steps for them. Okay, he can't be removed. ಅಲ್ಲಿ ಗಿಲ್ಟಿ ಅಂತ ರಿಪೋರ್ಟ್ ನಲ್ಲಿ ಪ್ರೂವ್ ಆಗ್ಬೇಕು, ತಪ್ಪಿತಸ್ಥ ಅಂತ ಹೇಳಿ ಪ್ರೂವ್ ಆಗ್ಬೇಕು. Yeah. If the committee finds the judge to be guilty of misbehavior or incapacity, then House can take up the consideration of motion. Next further steps start ಆಗ್ತದೆ. Based on the report only further steps start ಆಗೋದು. Next ಏನಿದೆ? Next, there will be a motion that will be passed in each houses with the help of 2/3 of members of both the houses present and voting, along with absolute majority. See, there will be a voting in a parliament regarding the removal of Judge of Supreme Court. This is the special majority. With the help of special majority, this judge can be removed. Okay, eventually I will tell you the majorities. Okay, but ನೆನ್ಪಿಟ್ಕೊಳ್ಳಿ ಯಾವುದು? Special majority. With the help of special majority, that will be passed in both the houses. ಲೋಕಸಭಾ, ರಾಜ್ಯಸಭಾದಲ್ಲಿ ಏನಾಗ್ತದೆ? ವೋಟಿಂಗ್ ಆಗ್ತದೆ ಇವ್ರ ರಿಮೂವ್ ಮಾಡಕ್ಕೆ. If it is passed, ಜಾಸ್ತಿ votes ಗಳು ಬಂತು ಅಂತಂದ್ರೆ ಏನು, that will be passed and it will be sent for the president. Now the president will remove the judge of Supreme Court. Directly the president can't remove any of the judges, whether it's a high court judge or whether it's a Supreme Court judge. These all the steps should take place. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ ಪ್ರೆಸಿಡೆಂಟ್ ಅವರು ರಿಮೂವ್ ಮಾಡಕ್ಕೆ ಸಾಧ್ಯ. ನಾನು ಪ್ರೆಸಿಡೆಂಟ್ ಇದೇನ ನಾನು ಸಡನ್ ಆಗಿ ರಿಮೂವ್ ಮಾಡ್ತಾನೆ ಅಂದ್ರೆ ಇಟ್ಸ್ ನಾಟ್ ಪಾಸಿಬಲ್. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇಸ್ ಗಿವಿಂಗ್ ದ ಸೇಫ್ ಗಾರ್ಡ್ಸ್ ಫಾರ್ ಜಡ್ಜಸ್ ಆಫ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ಹೈ ಕೋರ್ಟ್, ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ಇಂಡಿಯಾ, ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ಹೈ ಕೋರ್ಟ್. ಅವ್ರಿಗೊಂದು ಸೆಕ್ಯೂರಿಟಿ ಬೇಕಲ್ಲ when they are working as a judge. ಸಡನ್ ಆಗಿ ರಿಮೂವ್ ಮಾಡಿದ್ರೆ ಏನಾಗ್ತದೆ? ಇನ್ ಆರ್ಡರ್ ಟು ಮೇಂಟೈನ್ ದಟ್ ಸ್ಯಾಂಟಿಟಿ, ಆ ಪ್ಯೂರಿಟಿ, ಆ ಒಂದು ಮಹತ್ವ ಇರ್ಬೇಕು. ಅದು ಪ್ರೆಸಿಡೆಂಟ್ ನೋಡಿ, ಪ್ರೆಸಿಡೆಂಟ್ ಆಗಿರ್ಲಿ, ಜಡ್ಜಸ್ ಆಫ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಗಿರ್ಲಿ, ಅವ್ರಿಗೆ ಜಾಸ್ತಿ ರೆಸ್ಪೆಕ್ಟ್ ನೀಡ್ತೀವಿ ತಾನೆ ನಾವು. ಓಕೆ, ಅದೊಂದು ಭಕ್ತಿ ಇರ್ಲಿ ಅಂತ ಹೇಳಿ ಅದಕ್ಕೆ ಈ ತರ ಡಿಫಿಕಲ್ಟ್ ಪ್ರಾಸೆಸ್ ನ ಮಾಡಿದ್ದಾರೆ ಇನ್ ಆರ್ಡರ್ ಟು ರಿಮೂವ್ ದ ಜಡ್ಜ್ ಆಫ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ಹೈ ಕೋರ್ಟ್. ಸಡನ್ ಆಗಿ ಇದು ಟರ್ಮಿನೇಟ್ ಮಾಡೋ ತರ ಅಲ್ಲ ಕಾರ್ಪೊರೇಟ್ ಆಫೀಸ್ ನಲ್ಲಿ. Okay, this is difficult process. Understood? Next. Till now, none of the judges have been removed so far. Okay. But ಏನು ಅಂತಂದ್ರೆ previously in 1991, 1993 time ಅಲ್ಲಿ Supreme Court Judge V. Ramaswamy was about to be removed. ಬಟ್ ಏನು ಅಂದ್ರೆ ಅಲ್ಲಿ ಕಾಂಗ್ರೆಸ್ನವರು ಆಬ್ಸ್ಟೇನ್ ಆಗ್ಬಿಟ್ರು, ಅಂದ್ರೆ ನಾವು ವೋಟ್ ಮಾಡೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಲೋಕಸಭಾದಲ್ಲಿ ಅವರು ತಟಸ್ಥರಾಗ್ಬಿಟ್ರು. ದೆನ್ ಹಿ ವಾಸ್ ನಾಟ್ ರಿಮೂವ್ಡ್. ಟಿಲ್ ನೌ ನನ್ ಆಫ್ ದಿ ಜಡ್ಜಸ್ ಹ್ಯಾವ್ ಬಿನ್ ರಿಮೂವ್ಡ್ ಸೋ ಫಾರ್. ಓಕೆ, ನನ್ ಆಫ್ ದಿ ಪ್ರೆಸಿಡೆಂಟ್ ಈಸ್ ಆಲ್ಸೋ ರಿಮೂವ್ಡ್ ಸೋ ಫಾರ್. ಓಕೆ, ನೆಕ್ಸ್ಟ್. ದೇರ್ ಆರ್ ಡಿಫರೆಂಟ್ ಪವರ್ಸ್ ರಿಗಾರ್ಡಿಂಗ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. Okay, let us study each one. Which are those different powers and functions of Supreme Court? Arsha. Original jurisdiction, appellate, writ jurisdiction, advisory jurisdiction, powers of judicial review. Okay. Okay. First is original jurisdiction. Okay. When we see regarding the original jurisdiction, the Supreme Court will solve the cases regarding the disputes between a central government and state governments. The central government, state government madhya ಘರ್ಷಣೆ ಇರ್ತದೆ ನೋಡಿ, ಜಗಳಗಳು. Not political disputes. Political disputes ಬಿಟ್ಟು, that is related to the law. Okay, law ಮಾಡೋವಾಗ, law ಬಗ್ಗೆ ಇದ್ದಾಗ, if there is any dispute between central government and state government, in that the Supreme Court can give the judgment based on original jurisdiction. Original jurisdiction ಅಲ್ಲಿ ಕೆಲವೊಂದಿಷ್ಟು ಬರ್ತದೆ, ಅದರ ಪ್ರಕಾರನೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಡ್ಕೊಳ್ಬೇಕು. Based on that it can give the judgment. In other matters it can't involve. Okay, and it can't give the judgment. ಅದಕ್ಕೆ ಆದಂತ ಲಿಮಿಟೆಡ್ ಪವರ್ಸ್ ಇದೆ. ಓಕೆ, ಇಷ್ಟರಲ್ಲೇ ನಾನು ಏನ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ ನ ನೀಡಬೇಕು, ಬೇರೆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ನ ನೀಡೋದಿಲ್ಲ. Okay, let us see that. Firstly, see disputes between what? Central government and one or more states. That is central government versus state or states. Central government ಒಂದು ಲಾ ಮಾಡಿರುತ್ತೆ, states ಗಳೇ ಒಂದು ಲಾ ಮಾಡಿರುತ್ತೆ. There is a lot of frictions. ಅದ್ರ ಬಗ್ಗೆ it will solve the case. Next, between the center and any state or states. On one side ಅಂದ್ರೆ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಜೊತೆಗೆ ಕೆಲವೊಂದಿಷ್ಟು ಸ್ಟೇಟ್ ಅಥವಾ ಸ್ಟೇಟ್ಸ್ ಗಳು ಜಾಯಿನ್ ಆಗಿರ್ತದೆ. ಅದ್ರ ವರ್ಸಸ್ ಯಾರು ಮತ್ತೆ ಸ್ಟೇಟ್ಸ್ ಗಳು. ಥಿಂಕ್ ದಟ್ ಬಿಜೆಪಿ ಇಸ್ ಇನ್ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್. ಆ ಬಿಜೆಪಿ ರಿಲೇಟೆಡ್ ಪಾರ್ಟೀಸ್ ಎಲ್ಲ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ನಲ್ಲೇನು ಬಿಜೆಪಿ ಇರ್ತದೆ ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ. ಕೆಲವೊಂದಿಷ್ಟು ಸ್ಟೇಟ್ಸ್ ನಲ್ಲಿ ಅವರೆಲ್ಲ ಒಂದು ಬಣ ಆಗ್ತಾರೆ, ಅಪೋಸಿಟ್ ಪಾರ್ಟಿದವ್ರದ್ದು ಬೇರೆ ಬಣಗಳಾಗ್ತದೆ. ಓಕೆ, ಲೈಕ್ ದಟ್. ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲೂ ಬಿಜೆಪಿ ಇತ್ತು, ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲೂ ಬಿಜೆಪಿ ಇತ್ತು ಅಂದ್ರೆ ದೇರ್ ಈಸ್ ಅ ಸ್ಮೂತ್ ಫಂಕ್ಷನಿಂಗ್ ಆಫ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್. ಎಲ್ಲ ಸ್ಮೂತ್ ಆಗಿ ಗವರ್ನೆನ್ಸ್ ಆಗ್ತಾ ಇರುತ್ತೆ. ಅಲ್ಲಿ ಬಿಜೆಪಿ ಇದೆ, ಇಲ್ಲಿ ಕಾಂಗ್ರೆಸ್ ಇದೆ ಕರ್ನಾಟಕದಲ್ಲಿ. ದೇರ್ ವಿಲ್ ಬಿ ಫ್ರಿಕ್ಷನ್ ಬಿಕಾಸ್ ಪೊಲಿಟಿಕಲ್ ಪಾರ್ಟೀಸ್ ಆರ್ ಡಿಫರೆಂಟ್. ಓಕೆ, ಏನಾದ್ರೂ ಲಾ ರಿಲೇಟೆಡ್ ಅಂತ ಬಂದ್ರೆ ದೇರ್ ವಿಲ್ ಬಿ ಅ ಫ್ರಿಕ್ಷನ್ ಬಿಟ್ವೀನ್ ಬೋತ್. ಅಂಡರ್ಸ್ಟುಡ್? ನೆಕ್ಸ್ಟ್, ಬಿಟ್ವೀನ್ ಟೂ ಆರ್ ಮೋರ್ ಸ್ಟೇಟ್ಸ್. ಸ್ಟೇಟ್ಸ್ಗಳ ಮಧ್ಯ ಏನಾದ್ರೂ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಗಳಿದ್ರೆ, ಓಕೆ, ದಟ್ ಆಲ್. And exclusive of what? Exclusive of political disputes. Political disputes ಬಿಟ್ಟು law related disputes ಗಳನ್ನ it will solve. Understood? This is the original jurisdiction. Next. Next is appellate jurisdiction. Appellate. It is having 4 types. One is appeals in constitutional matters, appeal in civil matter, appeal in criminal matter, appeal by special leave. Appeal in constitutional matters andre, just concentrate here. Topmost court in India is Supreme Court. Adr ಕೆಳಗಡೆ High Court. ಅದ್ರ ಜೊತೆ ಯಾವ್ದು ಬರ್ತದೆ? Subordinate Court. In Karnataka, there are subordinate courts as well. One is in Dharwad, another one is in Gulbarga. Okay. Next, district courts. Okay. And see here, appeals in constitutional matter. It tells that whatever the judgment given by the High Court, if it is unconstitutional or whatever the confusion or the doubts the High Court is having regarding the law, it will directly transfer the case for Supreme Court. Or else, if the High Court has given one of the judgment, if it is unconstitutional, Constitution ವಿರುದ್ಧವಾಗಿತ್ತು ಅಂತಂದ್ರೆ, it will be quashed and Supreme Court will give the judgment. Understood? ಹೇಳ್ತದೆ ಅದು, ನೀನು ಸರಿಯಾಗಿ ತೀರ್ಪನ್ನ ನೀಡಿಲ್ಲ, ಸಂವಿಧಾನದ ವಿರುದ್ಧ ಆಗಿದೆ, ಅದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ವಿರುದ್ಧ ಆಗಿದೆ ಅಂತ ಹೇಳಿ it will give the judgment. Understood? Ultimately, the topmost court is Supreme Court. It is having the power to give the judgment. Next one, appeals in civil matters. Civil matter means here, property related disputes or tax evasion. Okay, ಈ ತರ ಇರುತ್ತೆ ನೋಡಿ. ಆ ಕೇಸಸ್ ನ ಏನ್ ಮಾಡಬಹುದು, ನಿಮ್ಗೆ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ನ್ಯಾಯ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಯು ಕ್ಯಾನ್ ಅಪ್ರೋಚ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಅಂಡರ್ಸ್ಟುಡ್? ಅಣ್ಣ ತಮ್ಮರ ಮಧ್ಯೆ ಜಗಳ ಇರ್ತದೆ ಅಥವಾ ಆನ್ಸಿಸ್ಟ್ರಲ್ ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಗಳನ್ನ ಇರ್ತದೆ. ಓಕೆ, ಫಸ್ಟ್ ನೀವು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಅದನ್ನ ಅಪ್ಲೈ ಮಾಡ್ಬೇಕು. ಅಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಬರ್ಲಿಲ್ಲ ಅಥವಾ ಜಜ್ಮೆಂಟ್ ಸರಿಯಾಗಿ ನೀಡ್ಲಿಲ್ಲ ನಿಮ್ ಪರ, ಇವನ್ ದೋ ಯು ಆರ್ ಹ್ಯಾವಿಂಗ್ ದ ವ್ಯಾಲಿಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂದ್ರೂ ಕೂಡ ಜಜ್ಮೆಂಟ್ ಇದಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಯು ಕ್ಯಾನ್ ಅಪ್ರೋಚ್ ದಿ ಹೈಕೋರ್ಟ್ ಬೈ ಅಪೀಲಿಂಗ್. ಅಲ್ಲಿನೂ ನೀಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಯು ಕ್ಯಾನ್ ಅಪ್ರೋಚ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಇಟ್ ಈಸ್ ಲೈಕ್ ದಟ್. ಸಡನ್ ಆಗಿ ನೀವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಲ್ಲಿ ಅಪೀಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, ಕೇಸ್ ಫೈಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಓಕೆ, ಲೋವರ್ ಹೈಕೋರ್ಟ್ಸ್ ಇಂದಾನೆ ಅಪ್ಪರ್ ಹೈಕೋರ್ಟ್ಸ್ ಹೋಗ್ಬೇಕಾಗ್ತದೆ. ಅಂಡರ್ಸ್ಟುಡ್? ದಟ್ ಈಸ್ ರಿಲೇಟೆಡ್ ಟು ದ ಸಿವಿಲ್ ಮ್ಯಾಟರ್ಸ್. ಸಿವಿಲ್ ಅಂದ್ರೆ ಇಟ್ ಈಸ್ disputes regarding property or else tax evasion, ಈ ತರ. And civil matters ಅಂತ ಬಂದ್ರೆ here ಡಿವೋರ್ಸ್ ಕೇಸಸ್ ಗಳು ಕೂಡ ಬರ್ತದೆ ಸಮ್ಟೈಮ್. ಬಟ್ ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಬಂದ್ರೆ ಅದು ಕ್ರಿಮಿನಲ್ ಆಗ್ತದೆ. If that woman is undergone the domestic violence, ಗಂಡ ಹೊಡೆಯೋದು ಅಥವಾ ಹೊಡೆಯೋದು ಅಥವಾ ಅತ್ತೆ ಮಾಮ ಹೊಡೆಯೋದು ಅಥವಾ ಡೌರಿ ಹರಾಸ್ಮೆಂಟ್ ನೀಡಿದ್ರೆ ದಟ್ ವಿಲ್ ಕಮ್ ಅಂಡರ್ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್. ಬಟ್ ಡಿವೋರ್ಸ್ ಬಗ್ಗೆ ಅಂತ ಬಂದ್ರೆ, ಇಫ್ ನಾನ್ ವೈಲೆನ್ಸ್ ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಆ ಡಿವೋರ್ಸ್ ಬಿಟ್ವೀನ್ ದಟ್ ಕಪಲ್ಸ್ ಅಂತಂದ್ರೆ ದಟ್ ವಿಲ್ ಬಿ ಸಿವಿಲ್ ಮ್ಯಾಟರ್. ಅದರಲ್ಲಿ ಪೊಲೀಸರು ಇನ್ವಾಲ್ವ್ ಆಗ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಪೊಲೀಸರು ಎಲ್ಲಿ ಇನ್ವಾಲ್ವ್ ಆಗಕ್ ಬರಲ್ಲ, ನಿಮ್ಮ ಒಂದು ಸಿವಿಲ್ ಮ್ಯಾಟರ್ಸ್ ಇನ್ವಾಲ್ವ್ ಆಗ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅವರು. ಓಕೆ, ಸ್ಪೆಷಲಿ ಫ್ಯಾಮಿಲಿ ರಿಲೇಟೆಡ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್. ಇಫ್ ಇಟ್ ಇಸ್ ಅ ವೈಲೆನ್ಸ್ ಇನ್ವಾಲ್ವ್ ಆಗ್ಬಹುದು, ವೈಲೆನ್ಸ್ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ವಾಲ್ವ್ ಆಗ್ಲಿಕ್ಕೆ ಅವ್ರಿಗೆ ಬರಲ್ಲ. ಅವ್ರು ಹೇಳ್ತಾರೆ ಜಸ್ಟ್ ಗೋ ಟು ದ ಕೋರ್ಟ್ ಅಂತ ಹೇಳಿ, ನಾವು ಮಂಡ್ರೆ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡ್ತಾರೆ ಅವರು. ಅಂಡ್ ಇಫ್ ದೇರ್ ಇಸ್ ಎನಿ ಡಿಸ್ಪ್ಯೂಟ್ ಬಿಟ್ವೀನ್ ರಿಗಾರ್ಡಿಂಗ್ ದ ಪ್ರಾಪರ್ಟಿ, ಸಡನ್ ಆಗಿ ಅಲ್ಲಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋಗೋದಲ್ಲ. ದಟ್ ಶುಡ್ ಬಿ ಸಾಲ್ವ್ ಬೈ ದಿ ಕೋರ್ಟ್ ಇಟ್ ಸೆಲ್ಫ್. ದಟ್ ವಿಲ್ ನಾಟ್ ಕಮ್ ಅಂಡರ್ jurisdiction ಆಫ್ ಪೊಲೀಸ್. ಓಕೆ. ಟ್ಯಾಕ್ಸ್ ಎವೇಷನ್, ಟ್ಯಾಕ್ಸ್ ನ ಕಡಿಮೆ ತುಂಬೋದು ಎಲ್ಲಿ, ಗೌರ್ಮೆಂಟ್ ಗಳಿಗೆ ಟ್ಯಾಕ್ಸ್ ಉಳಿಸ್ತಾರೆ ನೋಡಿ ಕೆಲವೊಬ್ರು, ಇಟ್ ಇಸ್ ಕಾಲ್ಡ್ ಎಸ್ ಟ್ಯಾಕ್ಸ್ ಎವೇಷನ್. ಓಕೆ, ಈ ತರ ಮಾಡಿದ್ರೆ. ಅಂಡ್ ಆಲ್ಸೋ ಈ ಪ್ರಾಪರ್ಟಿ ರಿಲೇಟೆಡ್ ಫ್ಯಾಮಿಲಿ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಎಲ್ಲ, ದಟ್ ಈಸ್ ಅ ಸಿವಿಲ್ ಮ್ಯಾಟರ್ಸ್ ಡೈರೆಕ್ಟ್ಲಿ. ದಟ್ ಒನ್ ಕ್ಯಾನ್ ಬಿ ಏನು ಅಂತಂದ್ರೆ ಆ ಸಿವಿಲ್ ಮ್ಯಾಟರ್ಸ್ಗೆ ಯು ಕ್ಯಾನ್ ಅಪ್ರೋಚ್. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಯು ಕ್ಯಾನ್ ಅಪ್ರೋಚ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಈ ತರ. ನೆಕ್ಸ್ಟ್ ಕಮ್ಸ್ ದ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್. ಸಿವಿಲ್ ಮ್ಯಾಟರ್ಸ್ ಅಂದ್ರೆ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಅಂದ್ರೆ ದ ಹೈಯೆಸ್ಟ್ ಪನಿಷ್ಮೆಂಟ್ ಇಂಡಿಯಾ ಇಸ್ ಡೆತ್ ಪನಿಷ್ಮೆಂಟ್. ಹೈಯೆಸ್ಟ್ ಪನಿಷ್ಮೆಂಟ್ ಯಾವುದು? ಗಲ್ಲು ಶಿಕ್ಷೆ, ಡೆತ್ ಪನಿಷ್ಮೆಂಟ್. See, that death punishment can be given by either a Supreme Court, either High Court, or either subordinate courts in India. If the death punishment given by the High Court, okay, that can be transferred for a Supreme Court. Okay. ಒಂದು ಅಪರಾಧಿಗೆ ಏನು ಅಂತಂದ್ರೆ ಡೆತ್ ಸೆಂಟೆನ್ಸ್ ಆಲ್ರೆಡಿ ಕೊಟ್ಬಿಟ್ಟಿದೆ ಇವಾಗ ಹೈಕೋರ್ಟ್. ಹಿ ಕ್ಯಾನ್ ಅಪೀಲ್ ಫಾರ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಅಂಡರ್ಸ್ಟುಡ್? ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೋದು, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬೇಸ್ಡ್ ಆನ್ ಅಗೇನ್ ಹಿಯರಿಂಗ್ಸ್, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಎಲ್ಲ ರಿಪೋರ್ಟ್ಸ್ ನ ನೋಡ್ಕೊಂಡು, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನ ನೋಡ್ಕೊಂಡು, ಪ್ರೂಫ್ಸ್ ನ ನೋಡ್ಕೊಂಡು, ಇಟ್ ಕ್ಯಾನ್ ಚೇಂಜ್ ದಟ್ ಡೆತ್ ಸೆಂಟೆನ್ಸ್ ಟು ರಿಗರಸ್, ಕಠಿಣ ಶಿಕ್ಷೆಗೆ ಒಳಪಡಿಸಬಹುದು. ಆರ್ ಎಲ್ಸ್ ಸೇಮ್ ಆಸ್ ಇಟ್ ಈಸ್ ಡೆತ್ ಸೆಂಟೆನ್ಸ್ ಕೊಟ್ಟಿರುವಂತ ಹೈಕೋರ್ಟ್ ಸೇಮ್ ಅದೇನೆ ಕೊಡ್ಬೋದು ತೀರ್ಪನ್ನ. ಓಕೆ, ದಟ್ ಈಸ್ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್. ಇನ್ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಅಂದ್ರೆ ಒಂದು ಡೆತ್ ಸೆಂಟೆನ್ಸ್ ಕೊಟ್ಟಿರೋರ್ಗೆ they can approach the Supreme Court, or else life imprisonment of more than life imprisonment of more than 10 years. 10 ವರ್ಷ ಜೈಲು ಶಿಕ್ಷೆ ಕೊಟ್ಟಿದ್ರು ಅಂತಂದ್ರೆ they can approach the Supreme Court. or life imprisonment, ಜೀವಾವಧಿ ಶಿಕ್ಷೆ ಕೊಟ್ಟಿದ್ರು ಅಂದ್ರೂ ಕೂಡ they can approach the Supreme Court. ಒಂದು ಡೆತ್ ಸೆಂಟೆನ್ಸ್, ಒಂದು ಜೀವಾವಧಿ ಶಿಕ್ಷೆ, that is life imprisonment. The next one is life imprisonment or more than 10 years. Okay, ಅಷ್ಟು ಶಿಕ್ಷೆ ಕೊಟ್ಟಿದ್ರೆ you can approach the Supreme Court. Okay. Next comes the appeals by special leave. This special leave includes all the matters in that. Okay, ಯಾವ ತರ ಅಂತಂದ್ರೆ matters related to the constitutional, again constitutional ಆಗಿರ್ಲಿ, civil matters ಆಗಿರ್ಲಿ, criminal matters ಆಗಿರ್ಲಿ, along with that ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಆಗಿರ್ಲಿ, ಲೇಬರ್ ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಆಗಿರ್ಲಿ, ರೆವಿನ್ಯೂ ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟ್ಸ್, ಅಡ್ವೊಕೇಟ್ಸ್ ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟ್ಸ್, ದಟ್ ವಿಲ್ ಬಿ ಹ್ಯಾಂಡಲ್ಡ್ ಇನ್ ದಿಸ್ ಒನ್. ಇವೆಲ್ಲ ಇನ್ಕ್ಲೂಡ್ ಇದ್ರಲ್ಲೇನು ಕೂಡ. ಅಲಾಂಗ್ ವಿತ್ ದಟ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಇತ್ತು. ಓಕೆ, ಅಂಡ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಆಗಿರ್ಲಿ, ನೆಕ್ಸ್ಟ್ ಒನ್ ರೆವಿನ್ಯೂ ಆಗಿರ್ಲಿ, ಲೇಬರ್ ಆಗಿರ್ಲಿ, ಅಡ್ವೊಕೇಟ್ಸ್ ಬಗ್ಗೆ ಆಗಿರ್ಲಿ, that will be given. Understood? ಏನೇ ಜಡ್ಜ್ಮೆಂಟ್ ನೀಡ್ ಇರುತ್ತಲ್ಲ ಈ ಲೋವರ್ ಕೋರ್ಟ್ಸ್ಗಳು, ಇಟ್ ಕ್ಯಾನ್ ಚೇಂಜ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ಬಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಈಸ್ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ದ ರೈಟ್ ಟು ಇನ್ವಾಲ್ವ್ ಇನ್ ದ ಕೇಸಸ್ ರಿಲೇಟೆಡ್ ಟು ದ ಕೋರ್ಟ್ ಮಾರ್ಷಿಯಲ್. ಮಿಲಿಟರಿ ಕೋರ್ಟ್ಸ್ ನಲ್ಲಿ ಇನ್ವಾಲ್ವ್ ಆಗ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಮಿಲಿಟರಿ ಕೋರ್ಟ್ಸ್ ನಲ್ಲಿ ಏನಾಗ್ತದೆ ಅಂದ್ರೆ, ಇಫ್ ಎನಿ ಆಫ್ ದ ಮಿಲಿಟರಿ ಆಫೀಸರ್ have done a crime, okay, ಅವರಿಗೆ ಎಲ್ಲಿ ಶಿಕ್ಷೆ ಕೊಡ್ತಾರೆ ಅಂದ್ರೆ ಮಿಲಿಟರಿ ಕೋರ್ಟ್ಸ್, ಕೋರ್ಟ್ ಮಾರ್ಷಿಯಲ್ ಅಂತ ಇರ್ತದೆ. ದೇರ್ ದ ಪನಿಷ್ಮೆಂಟ್ ವಿಲ್ ಬಿ ಗಿವನ್. If whatever the punishment that person has got, he can't approach the Supreme Court or High Court. He can only approach the president. Okay, ಕ್ಷಮಾ ಮಾಡ್ಲಿಕ್ಕೆ ಅಥವಾ ನಂದ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಪನಿಷ್ಮೆಂಟ್ ನ ಕಡಿಮೆ ಮಾಡ್ಲಿಕ್ಕೆ ಪ್ರೆಸಿಡೆಂಟಿಗೆ ಅಧಿಕಾರ ಇರ್ತದೆ. ನಾಟ್ ಇವನ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ಹೈಕೋರ್ಟ್. ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ಹೈಕೋರ್ಟ್ ಕಾಂಟ್ ಇನ್ವಾಲ್ವ್ ಇನ್ ದ ಕೇಸಸ್ ರಿಲೇಟೆಡ್ ಟು ದಿ ಕೋರ್ಟ್ ಮಾರ್ಷಿಯಲ್. ಅದೇ ಸಪರೇಟು, ಇವೆಲ್ಲ ಸಪರೇಟು. ಅಂಡರ್ಸ್ಟುಡ್? ಇಸ್ ದರ್ ಎನಿ ಡೌಟ್? ನೋ ಡೌಟ್ಸ್. Okay. Next comes the advisory jurisdiction. The same will be there in High Court chapter as well. Next comes the advisory jurisdiction. Advising. Advisory jurisdiction andre advising. Who will advise for whom? Here, the president can seek the advice from whom? That is Supreme Court. Whether it may be Chief Justice of India or Judges of Supreme Court, it doesn't matter. The president can seek the advice from Supreme Court, but it is not binding on the president. Okay. In two matters, president can take the advice from the Supreme Court related to the law. Okay. One is related to the national importance, other is related to the, that is law, or else whatever the matters related to the pre-constitution. Constitution ಆಗೋಕಿನ ಮುಂಚೆನೆ ಏನಾದ್ರು ಟ್ರೀಟೀಸ್ಗಳು ಅಗ್ರಿಮೆಂಟ್ಗಳು ಸೈನ್ ಮಾಡಿರ್ತಾರೆ ಬ್ರಿಟಿಷ್ ಟೈಮ್ ನಲ್ಲಿ, ಅದ್ರ ಬಗ್ಗೆ ಏನಾದ್ರು ಅವರಿಗೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಬೇಕಾಗಿತ್ತು ಅಂದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಅಪ್ರೋಚ್ ಮಾಡ್ತಾರೆ. Here, the president directly will not take the advice from the Supreme Court. ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಹೋಗಿ ಅವ್ರು ಅದ್ರ ಮುಂದೆ ನಿಂತ್ಕೊಂಡು ಆ ತರ ಕೇಳೋದಿಲ್ಲ. President will send the Attorney General of India. President will send whom? Attorney General of India. This Attorney General will go to the Supreme Court. Understood? Okay. Whatever the advice the president needs, he or she can ask whom? Supreme Court. But that advice will not be compulsory to implement that. ಅದನ್ನೇ ಮಾಡಬೇಕು ಅಂತ ಏನಿಲ್ಲ. ಅಂಡರ್ಸ್ಟುಡ್? ಅದನ್ನ ಸೇಮ್ ನಿಮ್ ತರನೇ ತಂದೆ ತಾಯಿಗಳ ಅಡ್ವೈಸ್ ಕೊಡ್ತಾರೆ ಅಂತ ತಗೊಳ್ಬಹುದು, ತಗೊಳ್ಳಿಕ್ಕಿಲ್ಲ. ಮಾಡ್ತೀರಾ ತಾನೆ? ಸ್ಪೆಷಲಿ ಗಂಡ್ ಮಕ್ಕಳು. ವಿಲ್ ಯು ಆಸ್ಕ್ ಯುವರ್ ಪೇರೆಂಟ್ಸ್ ಅಡ್ವೈಸ್ ಆರ್ ನಾಟ್? ಕೇಳ್ತೀರಾ? ಲೆಟ್ಸ್ ಗೋ ದೆನ್. This article is related to what? ಯಾವ ಆರ್ಟಿಕಲ್ ಸಂಬಂಧಪಟ್ಟಿದ್ದು? 143. Article 143. Under Article 143, President can seek or take the advice from Supreme Court. Understood? Any doubts? No. Next comes which one? See, different types of cases ನಲ್ಲಿ, different types of disputes ನಲ್ಲಿ ಕೆಲವೊಂದಿಷ್ಟು ಅಡ್ವೈಸಸ್ ನ ತಗೊಂಡಿತ್ತು. ನಿಮಗೆ ಗೊತ್ತಿರುವಂತದ್ದು ಯಾವುದು ಅಂದ್ರೆ ರಾಮ್ ಜನ್ಮಭೂಮಿ ಕೇಸ್. ಓಕೆ, ಅಯೋಧ್ಯದು. There was lot of dispute. 1991 ನಲ್ಲಿ there was huge clash between two communities, two religion, Hindu versus Muslim. Okay, ಬಾಬ್ರಿ ಮಸೀದಿ ಅಲ್ಲೇ ಇತ್ತು ಅಂಡ್ ರಾಮ ಜನ್ಮಭೂಮಿ. ಓಕೆ, ರಾಮ ಜನ್ಮಭೂಮಿನ ನಾಶ ಮಾಡಿ ಮುಗಲ್ಸ್ ದೇ ಹ್ಯಾವ್ ಎಸ್ಟಾಬ್ಲಿಷ್ಡ್ ದಿ ಬಾಬ್ರಿ ಮಸೀದಿ ಅಂತ ಹೇಳಿ. ದಟ್ ವಾಸ್ ಲಾಟ್ ಆಫ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ವೇರ್ ಗೋಯಿಂಗ್ ಆನ್ ಡ್ಯೂರಿಂಗ್ ದಟ್ ಟೈಮ್. 1993 ನಲ್ಲಿ ಪ್ರೆಸಿಡೆಂಟ್ ಟುಕ್ ದ ಅಡ್ವೈಸ್. ಓಕೆ, ರೀಸೆಂಟ್ಲಿ ಏನಾಯ್ತು? 2020 ಐ ಥಿಂಕ್ 20 or 2019 ನಲ್ಲಿ ದೇರ್ ವಾಸ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ವಾಸ್ ಬಿನ್ ಗಿವನ್. ಏನು ಅಂತಂದ್ರೆ ಅದೇ ರಾಮ ಜನ್ಮಭೂಮಿ, ಅದೇ ಅಯೋಧ್ಯದಲ್ಲಿ ಇಷ್ಟು ಎಕರ್ಸ್ ಆಫ್ ಲ್ಯಾಂಡ್ ದಟ್ ಶುಡ್ ಬಿ ಅಲೋಕೇಟೆಡ್ ಫಾರ್ ದಿ ಎಸ್ಟಾಬ್ಲಿಷ್ಮೆಂಟ್ ಆಫ್ ಟೆಂಪಲ್ ಅಂತ ಹೇಳಿ. There are 15 times advices ನ ತಗೊಂಡಿದ್ದಾರೆ ಟಿಲ್ ನಾವು. ಒರಿಜಿನಲ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ 1950 ಇಂದ ಹಿಡಿದು ಟಿಲ್ 2025 ವರೆಗೂ 15 ಒಂದು ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಪ್ರೆಸಿಡೆಂಟ್ ಹ್ಯಾವ್ ಟುಕ್ ದ ಅಡ್ವೈಸ್. ಫ್ರೀಕ್ವೆಂಟ್ಲಿ ತಗೊಳ್ಳೋದಿಲ್ಲ ಅಡ್ವೈಸಸ್ನ. ಒಂದು ಪ್ರೆಸಿಡೆಂಟ್ ಒಂದು ಸತಿ ತಗೊಂಡ್ರೆ ಅದೇ ಜಾಸ್ತಿ, ಇಲ್ಲಾಂದ್ರೆ ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ ಅವ್ರ ಟೆನ್ಯೂರ್ದಲ್ಲಿ. ಓಕೆ, ಇಫ್ ಇಟ್ ಈಸ್ ಆಫ್ ನ್ಯಾಷನಲ್ ಇಂಪಾರ್ಟೆನ್ಸ್, ಅವಶ್ಯಕತೆ ಇದೆ, ಒಂದು ಒಂದು ಆಕ್ಷನ್ ತಗೊಳ್ಬೇಕು ಅಂದಾಗ ದಿ ಕ್ಯಾನ್ ಟೇಕ್ ದ ಅಡ್ವೈಸ್. ಫಿನಿಶ್. ನೆಕ್ಸ್ಟ್ ಕಮ್ಸ್ ದಿ ಕೋರ್ಟ್ ಆಫ್ ರೆಕಾರ್ಡ್. Just write down this. Finish. Next comes a court of record. Court of record. Court of record means court of record ಅಂದ್ರೆ ಏನು ಹರ್ಷ? Yes, a judgments, whatever the proceedings, it takes place in the high court, supreme court or any district courts, that will be recorded. Okay, that testimonials will be recorded. It will be utilized in future cases. Movies alle nodidera ನೋಡಿ, ಹಳೆ ಕಾಲದಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೈ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನೀಡಿತ್ತು ಅಂತ ಹೇಳಿ ಲಾಯರ್ಸ್ ವಿಲ್ ಸಬ್ಮಿಟ್ ಫಾರ್ ದಿ ಜಡ್ಜಸ್ ದ ಸೇಮ್ ವೇ. ಓಕೆ, ಇಫ್ ದರ್ ಇಸ್ ಎನಿ ಡಿಸ್ಪ್ಯೂಟ್ಸ್, ಓಕೆ, ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಆಗಿರಲಿ, ಎನಿ ಕೇಸಸ್ ಬಗ್ಗೆ ಆಗಿರಲಿ, ದಟ್ ಆಲ್ ವಿಲ್ ಬಿ ರೆಕಾರ್ಡೆಡ್. ಓಕೆ, ದಟ್ ವಿಲ್ ಬಿ ಯುಟಿಲೈಸ್ಡ್ ಇನ್ ಫ್ಯೂಚರ್. ಪ್ರೀವಿಯಸ್ಲಿ ಈ ತರ ಜಡ್ಜ್ಮೆಂಟ್ ನೀಡಿದ್ರು, ನೀವು ಇದೇ ರೀತಿ ಜಡ್ಜ್ಮೆಂಟ್ ನೀಡಿ ಅಂತ ಕೇಳ್ಕೊಳ್ಬಹುದು lawyers. And also along with that there is a contempt of court. ಇದನ್ನ ಪಕ್ಕಾ ಕೇಳುವಂತ ಚಾನ್ಸಸ್ ಇದೆ ನಿಮ್ಮ UPSC ಅಲ್ಲಿ. Contempt of court. Contempt of court is either for civil matters or for criminal matters. In civil matters means whatever the judge have given the judgment, that judgment should be followed. If that judgment is not followed, if it is disobeyed, judgment prakara nadಕೊಳ್ಳಿಲ್ಲ ಅಂತಂದ್ರೆ that will be a contempt of court regarding the civil matter. ಜಡ್ಜ್ಮೆಂಟ್ ನೀಡಿರ್ತಾರೆ ಅಲ್ವಾ, ಅದ್ರ ಪ್ರಕಾರನೇ ನಡ್ಕೊಳ್ಬೇಕು. ಥಿಂಕ್ ದಟ್ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಪೆನಾಲ್ಟಿ ಅಂತ ಹಾಕಿದ್ರು ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ, ಪೆನಾಲ್ಟಿ ಶುಡ್ ಬಿ ಪೇಡ್. ಈ ಪೆನಾಲ್ಟಿ ನಾನು ಬರ್ಸೋದಿಲ್ಲ, ನಾನು ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್. ಪನಿಷ್ಮೆಂಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ, ಪನಿಷ್ಮೆಂಟ್ ನ ಅನುಭವಿಸ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್. ಪೊಲೀಸರಿಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟಿರ್ತಾರೆ ಈ ತರಾನೇ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ, ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್, ಅವ್ರ ಮೇಲೇನು ಕ್ರಮ ಜರುಗಿಸಬಹುದು. ಈ ತರ ಇರುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ಕಮ್ಸ್ ದಿ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್. ವಾಟ್ ಈಸ್ ದಟ್ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ರಿಲೇಟೆಡ್ ಟು ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್? ದೆನ್ ಅದ್ರ ಜೊತೆಗೆ scolding the judge and whatever the judgment the judge have given, every citizen of India is having the right to freedom of speech and expression. Okay, ಅವರು ಒಂದು ಥಾಟ್ಸ್ ಗಳೇನಿರುತ್ತೋ ಅದನ್ನ ಹೇಳ್ಬಹುದು, ಬಟ್ that person should not defame the judge or the judgment, and whatever that person sees, it should not lead to communal violence as well. ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದು ನೀಡಿರ್ತಾರೆ, ಆ ನೀಡೋದಕ್ಕೆ ಫೇರ್ ಆಗಿ ಜಸ್ಟ್ ಆಗಿ ಏನ್ ಮಾಡ್ಬೋದು, ಅದನ್ನ ಡಿಗ್ನಿಫೈಡ್ ಆಗಿ ನೀವು ಕ್ರಿಟಿಸಿಸಮ್ ಮಾಡ್ಬೋದು, ಫೇರ್ ಕ್ರಿಟಿಸಿಸಮ್ ಮಾಡ್ಬೋದು. ಬಟ್ ಕೆಲವೊಂದಿಷ್ಟು ಜನರು ಏನ್ ಮಾಡ್ತಾರೆ, ಸೋಷಿಯಲ್ ಮೀಡಿಯಾದಲ್ಲಿ ದೇ ವಿಲ್ ಸ್ಕೋಲ್ಡ್ ದ ಜಡ್ಜ್ ಅಂಡ್ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನ ಹೆಂಗ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಅದು ಕಮ್ಯುನಲ್ ವೈಲೆನ್ಸಿಗೆ ಆಗ್ಬೇಕದು. ಆ ತರ ಸ್ಟ್ರೈಕ್ ಗಳೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಮಾಡ್ಕೊಡುವಂಗೆ ಏನ್ ಮಾಡ್ತಾರೆ, ದೇ ವಿಲ್ ಜಸ್ಟ್ ಟೆಲ್ ಇನ್ ಎ ಸ್ಪೀಚ್. ಹೌದಾ, ಈ ತರ ಜನರ ಮಧ್ಯ ಅದು ಏನಾಗ್ಬಿಡ್ತದೆ, ಸಂಘರ್ಷಕ್ಕೆ ಒಳಗಾಗ್ತದೆ. ದಟ್ ಶುಡ್ ನಾಟ್ ಹ್ಯಾಪನ್. ಓಕೆ, ಅಂಡ್ ಇಟ್ ಈಸ್ ಆಲ್ಸೋ ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್. Criticism should be fair. Okay, even the news channel can criticize. Even the newspaper can criticize the judgment. Even we people can criticize the judgment, but it should be of fair criticism. Okay, and ಸುಮ್ನೆ ಬೇಕಾದಂಗೆ ಮಾತಾಡೋದಾಗೋದಿಲ್ಲ. ವಿತ್ ಪ್ರೂಫ್ ಕ್ರಿಟಿಸಿಸಮ್ ಮಾಡ್ಬೋದು. ಹೆಂಗೆ, ಲಾ ರಿಲೇಟೆಡ್. ನಮ್ ಸಂವಿಧಾನದಲ್ಲೇ ಈ ತರ ಒಂದು ಲಾ ಇದೆ ಅಂಡ್ ಅದ್ರ ವಿರುದ್ಧವಾಗಿ ಅವ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ತರ ನಾವು ಕ್ರಿಟಿಸಿಸಮ್, ಫೇರ್ ಕ್ರಿಟಿಸಿಸಮ್ ಮಾಡ್ಬೋದು. ನಾಟ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ಪರ್ಸನಲ್ ಮ್ಯಾಟರ್ಸ್ ಕ್ರಿಟಿಸಿಸಮ್ ಮಾಡೋದಲ್ಲ. ಅಂಡರ್ಸ್ಟುಡ್? ಓಕೆ, ರಿಲೇಟೆಡ್ ಟು ದ ಲಾ ಯು ಕ್ಯಾನ್ ಕ್ರಿಟಿಸೈಸ್. ಇಫ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಈಸ್ ಅನ್ಲಾಫುಲ್, ಇಫ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಈಸ್ ಅನ್ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್, ಆ ರಿಲೇಟೆಡ್ ಸ್ಪೆಸಿಫಿಕ್ ಆರ್ಟಿಕಲ್ ಹಾಕಿ ನೀವು ಏನ್ ಮಾಡಿ ಯು ಕ್ಯಾನ್ ಕ್ರಿಟಿಸೈಸ್. ಬಟ್ ಸುಮ್ನೆ ಬೈಯೋದಲ್ಲ, ತೆಗಳೋದಲ್ಲ. Is there any doubt? Contempt of court ಗೆ there is a penalty, there is punishment as well. Penalty is 2000 rupees. ಏನಾದ್ರು ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್ ಆಯ್ತು ಅಂದ್ರೆ 2000 rupees, or else punishment ಇರ್ತದೆ 6 months, or else both. Next comes the sixth one, that is power of judicial review. Power of judicial review. What is power of judicial review? Yeah, that one. Then Article 13. ನೆನ್ನೆನೆ ಹೇಳ್ದೆ ನೋಡಿ. What is the duty of judiciary? ನ್ಯಾಯಾಂಗದ ಕೆಲಸ ಏನು? It will give the reviews. It will just cross check what? Laws passed by legislature. Okay, it will give the judicial review that the law made by whom? Legislature. Which are the three pillars of constitution? Legislature, executive, judiciary. Whatever the laws created by the legislature, it will be cross checked by whom? Judiciary. Okay, it is like a third umpire. It will, if that law is correct, if that law is constitutional, then it is correct. If that law is unconstitutional, it will be declared as null or void. ರದ್ದು ಪಡಿಸ್ಬಿಡ್ತಾರೆ ಆ ಲಾನ, ಆ ಕಾನೂನನ್ನ. Okay, and also the laws made by what? Central government or state government. Not only a central government here. The law created by the central government, state governments, if that law is constitutional, it is okay. Okay, no problem. If that law is unconstitutional, ಸಂವಿಧಾನದ ವಿರುದ್ಧವಾಗಿತ್ತು, then it will be declared as null or void. This is called as power of judicial review. There any doubt? Law should not be illegal. Law should not be unconstitutional. Another doubt? Next. Which one? Other powers. The last one is other powers. Other powers. Other powers anta bandaga, the disputes related to the election of president, the disputes related to the election of vice president, for that the Supreme Court can give the judgment. Okay, the disputes of election of president, dispute of election of vice president. Okay, ಅದಕ್ಕೂ ಕೂಡ judgment na ನೀಡಬಹುದು. Write down that. It decides the disputes regarding the election of president and vice president. In this regard, it has the original, exclusive and final authority. Full stop. Next one is that, see, for UPSC, for SPSC, that is State Public Service Commission, take a example of KPSC. There will be chairman, there will be members in that UPSC, SPSC. Okay, if those people have misbehaved or incapacity, the Supreme Court can give advice for the president to remove that person from the chair, and that is binding on the president. ಅಲ್ಲೇನಿತ್ತು ಅಡ್ವೈಸರಿನಲ್ಲಿ, ದಟ್ ಈಸ್ ನಾಟ್ ಬೈಂಡಿಂಗ್ ಆನ್ ದ ಪ್ರೆಸಿಡೆಂಟ್ ಇತ್ತು, ಹೌದಾ? ದಟ್ ಈಸ್ ಅ ಡಿಫರೆಂಟ್ ಮ್ಯಾಟರ್. ಅಲ್ಲಿ ಏನ್ ಮ್ಯಾಟರ್ಸ್ಗೆ, ಒಂದು ನ್ಯಾಷನಲ್ ಇಂಪಾರ್ಟೆನ್ಸ್, ಇನ್ನೊಂದು ಪ್ರೀ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಮ್ಯಾಟರ್ಸ್ ರಿಲೇಟೆಡ್ ಟು ಟ್ರೀಟೀಸ್, ಅಗ್ರಿಮೆಂಟ್ಸ್ ಬಗ್ಗೆ. ಬಟ್ ಹಿಯರ್ ಇಟ್ ಈಸ್ ನಾಟ್. ಹಿಯರ್ that whatever there is inquiry regarding the chairman or the members of UPSC or SPSC, if that person is guilty, ತಪ್ಪಿತಸ್ಥ ಅಂತ ಪ್ರೂವ್ ಆಯ್ತು ಅಂದ್ರೆ president should remove, and that is binding on the president. ಅವ್ರನ್ನ ರಿಮೂವ್ ಮಾಡ್ಲೇಬೇಕು president ಅವರು. Understood? Is there any doubt? No, just write down. It inquires into the conduct and behavior of the chairman and members of UPSC or SPSC on the reference made by the president. Full stop. If it's found guilty of misbehavior, comma, it can recommend to the president for their removal, full stop. The advice given by the Supreme Court is binding on the president. Full stop. Have you understood this point? Is there any doubt? There will be chairman and members in UPSC and SPSC. If they are found guilty, tapitasta anta prove aitu andre, the Supreme Court will give the judgment. Based on that, president should remove. It is binding on the president to remove. Next point. Third one enide antandre, the Supreme Court will give the instruction for the High Court, for the lower courts to withdraw the cases or to transfer the cases for the Supreme Court. Okay. Supreme Court ಏನು ಮಾಡ್ತದೆ ಇಲ್ಲಿ? Supreme Court will instruct the lower courts, ಯಾವುದು? High Court ಆದ್ರೂ ಆಗಿರ್ಲಿ or else district courts ಆದ್ರೂ ಆಗಿರ್ಲಿ. It will give instruction for these lower courts to withdraw the case. ನೀವು ಹ್ಯಾಂಡಲ್ ಮಾಡ್ಬಿಡಿ ಕೇಸ್, or to pass or to transfer the case for the Supreme Court. Understood? And also, whichever the case that is pending, that should also be transferred. Pending cases ಗಳು ಇರ್ತದೆ ನೋಡಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನಾದ್ರೂ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ನೀಡ್ತು, ಆ ಪೆಂಡಿಂಗ್ ಕೇಸ್ ನಾನು ಕೊಡು ಅಂದ್ರೆ ಕೊಡ್ಲೇಬೇಕು. ನಾನು ಕೊಡೋದಿಲ್ಲ ಅಂತ ಅನ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. Supreme Court is having more power. Understood? Okay, write down. It is authorized to withdraw the cases pending before the High Court, and dispose them by itself. Full stop. It can also transfer a case or appeal pending before appeal pending before one High Court to another High Court. Concentrate here. What Supreme Court can do? It can tell to withdraw the case and to transfer the case, and it can assign that case to transfer from one High Court to another High Court. But a new case ನಡೆಸ್ಬಿಡಿ, ಅವ್ರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾನೆ ಅಂತ ಹೇಳ್ಬೋದು. Okay, that kind of rights Supreme Court is having. Next, see, whatever the law that is, whatever the judgment that is given by the Supreme Court, that is binding on all the courts throughout India. Supreme Court is the topmost court. ಅದೇನ್ ಜಡ್ಜ್ಮೆಂಟ್ ನೀಡ್ತದನೋ ಎಲ್ಲರೂ ಚಾಚು ತಪ್ಪದೆ ಕೇಳಬೇಕು. ಎಲ್ಲ ಹೈ ಕೋರ್ಟ್ಸ್ಗಳು, ಹೈ ಕೋರ್ಟ್ಸ್ ಗಳಾಗಿರ್ಲಿ, ಸಬಾರ್ಡಿನೇಟ್ ಕೋರ್ಟ್ಸ್ ಆಗಿರ್ಲಿ, ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ಸ್ ಆಗಿರ್ಲಿ, ಟ್ರಿಬ್ಯುನಲ್ಸ್ ಆಗಿರ್ಲಿ, that is binding throughout India. Understood? Write down that. A law is binding. A law is binding on all courts, all courts in India. Full stop. Its order or judgment is enforceable 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 throughout the country. Full stop. All authorities in the country should act in aid in aid of the support. Full stop. See, the power of the Supreme Court is that it is having the superintendence, that is supervising and controlling of all the courts in India. Supervise ಮಾಡೋದು ಹಂಗೆ ಎಕ್ಸಾಮ್ಗಳಲ್ಲಿ ಸೂಪರ್ವೈಸರ್ ಇರ್ತಾರೋ the same way the Supreme Court will supervise all the courts in India. It will control all the courts in India. Understood? And along with that, it will also control the tribunals. Yesterday I told you, tribunals means it is a kind of a court that will give the judgment for specific purpose. CAT ಅಂತ ಹೇಳಿದೆ ನೋಡಿ, CAT, KAT, that one. Okay, and along with that there are different types of tribunals as well. Labor ganta ಹೇಳಿ tribunals ಇದೆ, environment ganta ಹೇಳಿ ಒಂದು tribunal ಇರುತ್ತೆ. ಸ್ಪೆಷಲ್ ಪರ್ಪಸ್ ಸೆಟಪ್ ಮಾಡಿರ್ತಾರೆ. ಓನ್ಲಿ ರಿಲೇಟೆಡ್ ಟು ಎನ್ವೈರ್ಮೆಂಟ್ ಗೆ ಆ ಎನ್ವೈರ್ಮೆಂಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಅಷ್ಟೇ ಕೊಡ್ತದೆ ತೀರ್ಪು. ಸಡನ್ ಆಗಿ ಯು ಕಾಂಟ್ ಅಪ್ರೋಚ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ ಹೈಕೋರ್ಟ್ without the judgment of tribunals. The specific tribunal will give the judgment. Based on that, you can approach either Supreme Court or High Court. Okay, but directly you can't approach the Supreme Court or High Court in some of the matters. There will be tribunals. ಅವುಗಳ judgment ಕೊಟ್ಟಾದ್ಮೇಲೆ then you can appeal for the High Court or Supreme Court. Understood? Okay. Write down. It has a power of judicial superintendence in supervising and control over all the courts and tribunals By this we have completed Supreme Court chapter. Okay, take a break. We'll continue the High Court. High Court will be finished very soon now because already we have discussed the Supreme Court. Supreme Court, High Court ge just difference illa. Only 10% of difference is there. That we'll study. Just take a break. High Court. Okay. High Court, that deals with which article? From Article 214 to 231 of the Constitution. That will be coming under Part 6 of the Constitution. There are 25 parts. In that, the sixth part that deals with which? High Court. Okay. Article 214 to 231 that deals with High Court. 214, 15, 16, 17 till 31, 231 that deals with High Court. Just write down only this one. High Court, Article 214 to 231. Next. The institution of High Court originated in India in 1862 when the High Courts were set up at Calcutta, Bombay, Madras. Okay. In Calcutta, Bombay, Madras, the first High Court was been situated. Okay. In which era? During British era itself. During British era itself, we had Supreme Court, High Courts in India. Understood? Okay. First High Court was set up in Kolkata. First High Court was set up in Kolkata, next Bombay, next Madras. The fourth one is Allahabad. That is in UP, Uttar Pradesh. Understood? First High Court, it was established in 1962. And the Constitution of India provides for a High Court for each state. But 7th Constitutional Amendment Act, with the help of 7th Constitutional Amendment Act, Constitution Amendment, Constitution changes, with the help of 7th Constitutional changes in 1956, it states that Parliament to establish common High Court for 2 or more states. 2 or more states on the High Court, or else the Union Territory. As we have discussed, there are 8 Union Territories. That Union Territories have merged with the states to have formed one common High Court. Munche enittu, for every state it had one High Court, but with the help of 7th Constitutional Amendment Act of 1956, now there is a common High Court for 2 or more states. Let us study that as well. Okay, which are the common High Courts that we are having in India? Totally there are 25 High Courts in India. Understood? They might ask you, consider the following statement regarding High Court. First option, every state is having the High Court. Second option, with the help of 7th Constitutional Amendment Act, the High Courts, the common High Courts have been established either in 2 or more states or with the help of Union Territory. Third option, 28 High Courts are there in India. Fourth option, none of the above. Which is the answer? B. First statement ಏನು ಹೇಳಿದ್ದೆ? Every state is having the High Court ಅಂತ ಹೇಳಿದ್ದೆ. That is, option is wrong. Second one, with the help of 7th Constitutional Amendment Act 1956, common High Court will be there for 2 or more states or Union Territory. C, that is 28 High Courts are there in India. Why I have mentioned 28? How many states we are having in India? 28 states. That's why I just told 28 states. A ಮತ್ತೆ C same. C, that option B is like this I have just told. Okay. Have you understood this one? Just write down 25 High Courts. 25 High Courts are established in India. 25 High Courts are established in India. 25 high courts are established in India. First high court situated at Calcutta. Any doubts in this? No doubts. Next. At present, since from 2019, we are having 25 high courts. And out of 25 high courts, only 3 high courts have jurisdiction over more than one state. Okay. 3 high courts are common high courts in India. Rest of them are a high court for one state. And let us see those. Among the 8 union territories, Delhi alone has the separate high court. How many union territories are there? 8. Which are those? Ladakh, Jammu and Kashmir. Let's start from north. Ladakh, Jammu and Kashmir, no high courts. Then Chandigarh. Okay. For Jammu and Kashmir, there was a high court. Okay. Since it has become union territory, now adukke enu andre iva common high court between Ladakh and Jammu and Kashmir. Jammu and Kashmir, Ladakh, Delhi, Chandigarh, that is the common high court for both Punjab and Haryana. Okay. Delhi is having the own single high court. Supreme Court to Delhi alida, High Court to Delhi alida. Next comes Daman and Diu, Dadra and Nagar Haveli. That is common for the other court. Let us see that. Next, Puducherry, Lakshadweep, Andaman and Nicobar. Okay. And those have merged with other. Okay, let us see that. Here, the union territories of Jammu and Kashmir, Ladakh have a common high court. Both the union territories are having one common high court. Previously, Jammu and Kashmir, Ladakh was a state, but now it was being declared as union territories. Since they have declared as union territories, now they are having this common high court for both union territory, Jammu and Kashmir, Ladakh. Next, the other territory falls under the jurisdiction of different state high courts. Let us see that as well. Composition and appointment. What is the strength of high court that we will be studying? What is the strength of Supreme Court? Strength of Supreme Court 34, 33 plus 1. Let us see the strength of court. See, the strength of the high court is not fixed. It depends on time to time. They might increase or they might decrease the strength of the high court members, because it is based on a population itself. Okay. If the less population in that state, lesser the strength of high court. If there is a more population in that state, more number of judges will be appointed. Okay. Let us see that. Every high court consists of Chief Justice of High Court and such other judges as the President may from time to time deem necessary to appoint. President is having the right to increase or decrease the strength of High Court judges. There will be one compulsory Chief Justice of High Court. Okay, how we will be having the Chief Justice of India? The same way there will be a head of the judges. In that, he will be Chief Justice of High Court. Okay. And thus the Constitution does not specify the strength of the High Court. Strength of the High Court is not being given in a Constitution. It leaves to the discretionary power of President. President from time to time he or she can increase the strength of High Court. Accordingly, President determines the strength of High Court from time to time depending on its workload. ಜಾಸ್ತಿ ಕೇಸಸ್ಗಳು ಪೆಂಡಿಂಗ್ ಇತ್ತು ಅಂದ್ರೆ it will increase. The strength will be increased. Lesser workload, strength will be decreased. Is there any doubt? There is no fixed strength in the High Court like a Supreme Court. Next, qualification for becoming the judge. Enide first, citizen of India. Second one, he should have held a judicial office in the territory of India for 10 years. You know, judicial office. Judicial office means at least a district judge agi. Minimum district judge agi 10 years ಸೇವೆ ಸಲ್ಲಿಸಿರಬೇಕು. Then he can become a judge of High Court. Or then what it is? He should have been an advocate of High Court for 10 years. In order to become the judge of High Court, at least you should be an advocate of High Court for 10 years. Understood? Okay. Next, from the above, it is clear that Constitution has not prescribed the minimum age for becoming the judge of High Court. There is no minimum age, but there is a maximum age. The retirement age of the High Court judges is 62 years. Is there any doubt in this? No doubts. The first one is citizen of India. Second one is at least he would have held the judicial office. It is as being a district magistrate or district court judge. Okay, 10 years adru irbeku. Or else he should serve as advocate of High Court for 10 years. Understood? Just write down in a key points. Important main keywords na ಅಷ್ಟೇ ಬರ್ಕೊಳ್ಳಿ. Judicial office, write down that also. Finish. In order to become the district judge, what are the qualification? Supreme Court note. Qualification of Supreme Court we have seen. Qualification of High Court we have seen. What is the qualification of becoming the district judge? Citizen of India. Next. Yes. Here, recently, just 3-4 days back, Supreme Court has given a judgment. There was a 5 judges bench. 5 judges in a Supreme Court. They have given the judgment that in order to become the district judge, at least you should be an advocate for 7 years. Or judicial officer, that is civil judge. Totally 7 years agbeku. Either a 7 years of as advocate or else total serving period should be advocate plus judicial officer agi total 7 years agbeku. You are eligible for appointment of district judge. Okay, think that he has served as an advocate for 4 years and he has served as a judicial officer, that is civil judge agi. He has worked for 3 years. He is eligible for becoming the district judge. Understood? This is the qualification eligibility. Is there any doubt? Okay. Previously it was not like that, but recently they have made it flexible. Understood? Next, appointment of High Court judges. Who will appoint them? President, not the governor. Don't get confusion. Okay. President will appoint the High Court judge. President is the one who will remove. Appointment ಮಾಡೋರು ಅವರೇ, remove ಮಾಡೋರು ಅವರೇ. Resignation ಯಾರಿಗೆ ಕೊಡಬೇಕು? Administration of oath ಯಾರು ಕೊಡ್ತಾರೆ? That is we should see. The Chief Justice is appointed by the President after consultation with Chief Justice of India. See, in order to appoint the Chief Justice of High Court, in order to appoint Chief Justice of High Court, he will be appointed by President. But yaar consultation kodbeku? His name should be given as a recommendation. The consultation is taken from Chief Justice of High Court. Okay. Here what says? The Chief Justice of India and the governor of a state concerned. Okay. Chief Justice of India plus that governor will recommend a name. This Chief Justice, this person should become a Chief Justice of High Court. Yari kodtare a recommendation. That consultation will be taken from the President. President solely he will not appoint anybody as a High Court judge. He will take the recommendation from some people. Who are those? Chief Justice of High Court, Governor of State. Governor of State ge yaar help kodtare hinde? CM and Council of Ministers. Governor is also not having the sole authority to appoint this person as a Chief Justice of India. Avrige hinde yaar help kotirtara? CM and Council of Ministers. They are the one who will advise the governor. Ivre beku antare. Then consultation with Chief Justice of India. Then that list will be given for President. President will appoint a person for Chief Justice of High Court. President is not having sole authority to take the decision in India. Governor is not having the power to take the sole decision in India. Our Hindi yaar helkodbeko, the advice should be given by these members. For governor it is CM and Council of Ministers of States. Nama state ministers irtaralva ಅವರು ಕೂಡ. But for the president, it is whom? President yaar advise ಮಾಡ್ತಾರೆ? Prime Minister plus Council of Ministers, that is central ministers. They will advise ಹಿಂಗೆ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರು ಮಾಡ್ಬೇಕಾದ್ರೆ. Next, in case of a common high court for 2 or more states, the governor of all the states concerned are consulted by the president. Common high court ಇದೆ ಅಲ್ವಾ, ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ತಾರೆ? If there are 2 states ಇದ್ರು ಅಂದ್ರೆ 2 governors of that state will be taken as consultation. Understood? Not only one governor here. ಎಷ್ಟು ಕಾಮನ್ ಹೈಕೋರ್ಟ್ ಎಷ್ಟು ಸ್ಟೇಟ್ಸ್ ಗಳಿರ್ತದೋ ಅಷ್ಟು ಸ್ಟೇಟ್ ಗವರ್ನರ್ಸ್ ಗಳದು ದೇ ವಿಲ್ ಟೇಕ್ ದ ರೆಕಮೆಂಡೇಶನ್ಸ್. Understood. CJ is only one person in India. His consultation is required. It is mandatory. Along with the governor's consent. Governor andre illi hinde ಇವರೇ ಹೇಳೋದು. Understood. In order to appoint one chief justice of High Court, ಇಷ್ಟಂದ್ರೆ ಎಲ್ಲರದು recommendation ಬೇಕು. Not only a president. President is a nominal head ಅಂತ ಅದಕ್ಕೆ. Is not having the real power. Real power will be having the PM or CM. ಮನೆಯಲ್ಲಿ ಹಿರಿಯರು ಹೆಂಗಿರ್ತಾರೆ ನೋಡಿ, ಮನೆಗೆ ಹಿರಿಯರ್ ಬೇಕಾ, ಅಜ್ಜ ಅಜ್ಜಿ, ಸೇಮ್ ವೇ ಲೈಕ್ ದಟ್ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂಡ್ ಗವರ್ನರ್. ಅವ್ರ ಮಾತನ್ನ ನೀವು ಕೇಳೋದಿಲ್ಲ, ನಿಮ್ಗೆ ಏನ್ ಅನ್ಸುತ್ತೆ ನೀವು ಹಂಗೆ ಮಾಡ್ತಾ ಇರ್ತೀರಿ, ಬಟ್ ಅವ್ರಲ್ಲಿ ಇರಬೇಕು. ದ ಸೇಮ್ ವೇ ಲೈಕ್ ದಟ್. That is binding according to Article 74. According to Article 74, whatever the Council of Ministers, along with the PM, whatever the advice they give, that is binding on the President. With the help of which Constitutional Amendment Act? 9th Constitutional Amendment Act. Okay. Previously, during original Constitution, there was not binding. Whatever the advice that is given by the PM, Council of Ministers, that was not binding on the President. And then Parliament decided to amend the Constitution. ಇಲ್ಲ ಹಿಂಗಾದ್ರೆ ಈ ಪ್ರೆಸಿಡೆಂಟ್ ಅವ್ರ ನಮ್ಮ ಮಾತು ಕೇಳೋದಿಲ್ಲ, ನಮ್ಮ ಅಡ್ವೈಸ್ ತಗೊಳ್ಳೋದಿಲ್ಲ ಅಂತೇಳಿ ದೇ ಚೇಂಜ್ ದ ಆರ್ಟಿಕಲ್. ದೇ ಮಾಡಿಫೈಡ್ ದ ಆರ್ಟಿಕಲ್ 74. Now it has made binding. ಕೇಳಲೇಬೇಕು. There was a huge dispute, huge clashes between Jawaharlal Nehru and Rajendra Prasad. First Prime Minister, first President of India. That's why they made it binding. See, Parliament can change any laws, but it should be constitutional. Is there any doubt? Oath. Who will administer the oath for Chief Justice of High Court and Judges of High Court? ಯಾರು ಕೊಡ್ತಾರೆ? ಪ್ರಮಾಣ ವಚನ ಯಾರ ಮುಂದೆ ಸ್ವೀಕರಿಸಬೇಕು ಅವರು? In front of whom? The Governor of State. There, the Chief Justice of India plus judges of Supreme Court, for them, who will administer the oath? President. In front of President, they should administer the oath. All these people. But when it comes to the state level, the Chief Justice of High Court along with judges of High Court, they should administer the oath in front of Governor of State. Understood? Appointment ಮಾಡೋರು President. Don't get confusion. Here, the appointment process, appointment, removal, resignation, administering of oath, everything will be made by the President itself for these people. But for here, appointment will be made by President. Administration of oath, that should be in front of Governor. Removal is also from the President. Appointment ಮಾಡೋರು ಅವರೇ, ರಿಮೂವ್ ಮಾಡೋರು ಅವರೇ. ಬಟ್ ಪ್ರಮಾಣ ವಚನ ಅವ್ರ ಮುಂದೆ ಸ್ವೀಕರಿಸಬೇಕು. Understood? Resignation will be given for the Governor itself. Is there any doubt? Tenure. The tenure is till the age of 62. But for our Supreme Court judges, it was 65. Here it is 62. He can resign for the President, not for the Governor. Governor will only administer the oath, but everything that will be under the hands of President itself. He can be moved by the President. And very important, he vacates his office when he is appointed as Judge of Supreme Court or when he is transferred to another High Court. See, judges of High Court can be transferred from one High Court to another High Court. That will be made by the President itself. President will transfer that judges of high court from one high court to another high court. And also he should vacate the office of the previous high court. ಎಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿರುತ್ತೋ ಅಲ್ಲೇ ಅವರು ಕೆಲಸ ಮಾಡಲೇಬೇಕು. Is there any doubt? Removal of judges, as I told you, okay, that we will just again explain it. You can only just tell me. Just write down. Appointment, just write down like this, only in keywords. Appointment made by the president. Consultation with CJI, governor of state concerned. Next, resignation, oath, removal. Resignation will be given for a president. Oath will be administered by the governor. Next, removal will be made by the president. ಈ ತರ ಕೀಬೋರ್ಡ್ಸ್ ಬರ್ಕೊಳ್ಳಿ. Write down the note somewhere else that Supreme Court has been established with the help of Article 124. High Court is been established with the article of 214. Supreme Court established with the article 124. High Court is 214. ಎಲ್ಲಾದ್ರೂ ನೋಟಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ ಮೇಲ್ಗಡೆ ಮೂಲೆಯಲ್ಲಿ. Finish. See, there are different types of courts in India. One is the highest court in India is Supreme Court. Next comes the 25 high courts. The next comes the subordinate courts, that is lower courts. Lower courts is of having two types. One is civil, for civil matters, civil courts. One is for criminal courts. In that civil court, it is having a junior division, senior division. Okay. And criminal courts nallinu kuda it is having the sessions court, additional sessions court anta irtade. Allinu kuda first class, second class courts gal irtade. Next, there are tribunals, special courts anta. Special courts, have you heard the name family court? The family court that is related to the marriage, divorce, inheritance of property. Okay, property dispute ittu andra for that. Next, labor courts related to the industrial disputes. Next, consumer court. Kilidira Consumer Protection Act. Okay. And what is that consumer court? What is Consumer Protection Act? Have you heard that? Whatever you purchase the goods, if that retail shops, if the charges more than the MRP, or if the retail shop owners, if they sell the expired goods for you, then what you can go? Can directly approach the Consumers Court, not the High Court, District Court, and Supreme Court. Okay, special courts will be there. Next comes the Juvenile Justice Board. That is, the cases related to the minors, the children below the age of 18. If they have committed a crime, for them there is a juvenile courts in India. Next, MACT, that is Motor Accident Claims Tribunal, compensation for accidents. Okay. Next, that is National Green Tribunal, as I told you regarding the environmental issues. Okay, think that any of the factory is just liberating lot of toxic substances either in river or else in a, if it does the sound pollution, noise pollution, that is noise pollution, or water pollution, or else the air pollution, then you can approach the National Green Tribunal. Next, as I told you, CAT, Central Administrative Tribunal. All these government employees at the central level, they can approach this CAT, Central Administrative Tribunal. Once you become IAS officer, if there is any dispute, you should approach CAT, not the High Court, Supreme Court. Have you understood? Next, bank loan recovery cases. For that, there is a DRT, that is Debt Recovery Tribunal. Bank loans ಏನಾದ್ರು ತಗೊಂಡಿದ್ರೆ ಅಂದ್ರೆ ಈ ಕೋರ್ಟ್ಸ್ ಗಳಿಗೆ ಹೋಗ್ಲಿಕ್ಕಾಗಲ್ಲ. There is a tribunal for that. Special courts are there. Have you understood all this? Okay. Okay, next. Oath. Have you written that oath? Oath will be administered by governor. Next, write down the tenure in your keywords. 62 age, resignation, removal. Okay. Last one question. The retired judges, can they be reappointed? No. They can't be reappointed. In special cases, they can be reappointed. Only in special cases. That president consultation ತಗೊಳ್ಬೇಕು ಮತ್ತೆ. In order to reappoint the retired judges, he can also work as a judge for temporary basis. But there should be a consultation by the CJI. Thing that is, if there is a vacancy in a Supreme Court, okay, and eligible judges sigilla antandhaga, reappointment can be done for temporary basis for handling the cases or workload. Understood? Retired judges can serve as an advocate in any high court in future? No. Retired judges cannot. Again, these retired judges of Supreme Court are prohibited from pleading or acting in any court. Why so? Our practice ಮಾಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಇಲ್ಲ. Once they get retired, they are not having the right to practice in any of the court. Why so? Why so? There might be a reason. Okay. ಸಿ ಆ ಫ್ಯೂಚರ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನೋದು ಮಾಡ್ಕೊಳ್ಬಾರ್ದು ಅಂತ ಹೇಳಿ, ಓನ್ಲಿ ಫಾರ್ ದಟ್ ರೀಸನ್. ಸಿ ವೈಲ್ he is serving as a Supreme Court judge, okay, he might favor in future in other cases. ಅದಾಗಬಾರ್ದು ಅಂತ ಹೇಳಿ. ಇವಾಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ ಆಗಿದ್ರು, ರಿಟೈರ್ಮೆಂಟ್ ಆದ್ರು, ಅದೇ ಕೇಸ್ನ ಮತ್ತೆ ಇವರು ಅಡ್ವೊಕೇಟ್ ಆಗಿ ಡಿಫೆಂಡ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ, ಓಕೆ, ದಟ್ ಶುಡ್ ನಾಟ್ ಬಿ ಡನ್. ಅದಕ್ಕೇನು ಅಂತಂದ್ರೆ ದೇ ಆರ್ ಬಾರ್ಡ್ ಫ್ರಾಮ್, ದೇ ಆರ್ ಪ್ರೊಹಿಬಿಟೆಡ್ ಫ್ರಾಮ್ practice unless and until if the President and Chief Justice of India tells them to reappointment for temporary basis, adhik avakash ide for reappointment as a judge, but not for practicing in any of the court. Understood? Future alli favor ಮಾಡಬಾರದು ಅಂತ ಹೇಳಿ ಯಾವುದೇ ಕೇಸ್ ನಲ್ಲಿ. That's why. Next. Next is removal of judges. As I discussed the removal of judges of Supreme Court. Firstly, what it says. Removal motion should be signed by 100 members of Lok Sabha or 50 members from Rajya Sabha. If it is passed, if the 100 members have been signed from Lok Sabha, then it is submitted for Speaker. If they are from Rajya Sabha, they will be submitted for Chairman. Both these are having the right to accept that motion or reject that motion, whatever the proposal, that signed proposal they have given. Then if they accept, what they can do, they can form the 3-member committee. In that 3-member committee, who will there? Chief Justice of India or Judge of Supreme Court, Chief Justice of High Court, and distinguished jurist. If the committee finds that judge is found guilty, ತಪ್ಪಿತಸ್ಥ ಅಂತ ಗೊತ್ತಾಯ್ತು ಅಂದ್ರೆ, then it will be passed in both houses of parliament with the help of special majority. Through the voting, that judge can be removed. That voting is special majority. Okay, in Lok Sabha and Rajya Sabha, in both houses it should get passed. Then it will be sent for President. Then President will remove that judge. This is the procedure for removing the judge of High Court and Supreme Court. The same procedure. Next. Okay, which are the jurisdiction and powers of High Court? There we have studied original jurisdiction, appellate, advisory, okay, and court of record, judicial review. 7 we have studied that. But here there is a original jurisdiction. Okay. Here the original jurisdiction is of different types. Just write down each one. Put the heading jurisdiction and powers of High Court. Jurisdiction and powers of High Court. Jurisdiction and powers of High Court. The first one is original jurisdiction. Original jurisdiction. First, disputes related to the election of member of parliament or state legislature. The first one says that disputes related to what? Elected members of MP. MP related election disputes idre, or else MLA, MLC related election disputes idre. That court is having the authority to hear that kind of cases in a first instance itself. Next, the second one, regarding revenue matters. Second one, regarding revenue matters. See, this is MP of Lok Sabha and Rajya Sabha both. Member of Parliament means both the MP of Lok Sabha and Rajya Sabha. Regarding matters of revenue or act or an act or an act ordered or done in revenue collection. Revenue matters. Just write down only revenue matters. Revenue matters or an act. Revenue matters or an act ordered or done in revenue collection related to the revenue. Revenue in the form of taxes. Third one, enforcement of fundamental rights to the citizens. There are fundamental rights that is given for the citizens. The High Court, Supreme Court is having the right to enforce, to give these fundamental rights for the citizens. Fundamental rights will be created by the Parliament. Concentrate here. Fundamental rights will be created by the Parliament. In order to implement them, who can enforce? Yaar herbodu? Jarge herodu? It is High Court or Supreme Court. Understood? It is created by the Parliament, not by the Supreme Court. Lawmakers are central government or state government. But the enforcing of that, implementing of that will be made by the High Court or Supreme Court. Okay. Next jurisdiction. Sorry. Next writ jurisdiction. This is first one, original jurisdiction. Next comes the writ jurisdiction. Writ. Writ jurisdiction. If there is violation of your fundamental rights, what you will do? If the violation of your fundamental rights, you can approach Supreme Court or you can approach High Court. For approaching the Supreme Court, you need the Article 32. For High Court, it is 226. Here, concentrate. The High Court is having more power than the Supreme Court in this matter. ಬೇರೆ ಯಾವ ಮ್ಯಾಟರ್ ಅಲ್ಲೂ ಹೈಕೋರ್ಟ್ಗೆ ಜಾಸ್ತಿ ಪವರ್ ಇಲ್ಲ. ಓನ್ಲಿ ಇನ್ ರಿಟ್ jurisdiction it is having more power. That tells if there is any violation of fundamental rights, you can approach Supreme Court. If there is violation of fundamental rights along with the any other purpose, any other purpose means if there is any violation of ordinary legal rights as well, means a property dispute, you can approach High Court. Understood? Along with the fundamental rights, if there is any violation of legal rights, you can approach High Court. In this writ jurisdiction, High Court is having more power. Here, if there is any violation of only fundamental rights, you can approach Supreme Court. If there is a violation of fundamental rights and legal rights, you can approach High Court. And it can give the judgment for the cases that is outside the jurisdiction also. Karnataka High Court ida. Karnataka High Court can give the judgment if the case, if that incident is happened within Karnataka or if it is related to the Karnataka as well. Understood? Yaudo ondu think that if any of the crime has been happened in Karnataka by the other person outside the Karnataka person, he is not Kannadiga, Karnataka belong agala, he is Bengali. Okay, Karnataka High Court can give the judgment or either transfer that case there. But illi enadru agittu andre, if that action has been took place in that jurisdiction, this High Court is having that right to give the judgment for that whatever the crime or action that has been done here. ಈ ತರ ಇರ್ತದೆ. Within the jurisdiction, ಕರ್ನಾಟಕದಲ್ಲಿ ಏನಾದ್ರೂ ಆಯ್ತು ಅಂದ್ರೆ Karnataka High Court can take up that case. Understood? Write down. If there is any violation, can I dictate? Should I dictate? Just write down. If there is any violation of fundamental right, if there is any violation of fundamental right, the person can approach Supreme Court. The person can approach Supreme Court under Article 32. Under Article 32. Full stop. However, the High Court is having wider power than the Supreme Court, comma, if there is any violation of fundamental rights and any other purpose, write down in a bracket. Any other purpose means ordinary legal right. Ordinary legal right. Bracket close. The High Court can issue writs to any person, comma, authority and government not only within the territorial jurisdiction, but also outside its territorial jurisdiction. if the cause of an action, if the cause of an action arises within territorial jurisdiction. Okay, next, appellate jurisdiction. Third one. Appellate. Appellate means appealing. Appeal ಮಾಡೋದು. High Court or Supreme Court. There also you have studied appellate jurisdiction. Illi Supreme Court. Appellate regarding constitutional matter, appellate regarding civil matter, criminal matters, appellate regarding special leaves anta heli. There you have studied. The same way here. Whatever the subordinate courts or a lower courts have given the judgment, or whichever the cases that are pending, that can be appealed for the High Court. The lower court and subordinate courts are having less power than the High Court. Lower court and the district court. District court, is it having more power than the High Court? No. Whatever the judgment, whatever the proceedings that is happening in the district court or subordinate court, that can be transferred for the High Court for appealing. Okay, ಮತ್ತೆ ಅಲ್ಲಿ judgment ನೀಡ್ತದೆ ಅದು. Just write down. For civil matters, the orders and judgments of a district court, comma, additional district courts and other subordinate courts lie directly to the High Court. Full stop. Next, civil matters. Sorry, for criminal matters. Concentrate here. For criminal matters, write down, for criminal matters. For criminal matters, the courts will give the punishment. If the lower courts, district courts, that is sessions court, additional sessions court, if they give the punishment of more than 7 years, you can appeal for High Court. Understood? ಒಂದು ಯಾವುದೋ ಒಂದು ಅಪರಾಧಿಗೆ more than 7 years, if he has got the punishment from the district courts like sessions court and additional sessions court, he can approach what? High Court. Or Even the Sessions Court, additional Sessions Court is having the right to give the death punishment. But it should cross-check whether that person have appealed for the High Court or not. Before giving the punishment, ತಿಳ್ಕೊಳ್ಬೇಕು ಆ ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಆರ್ ಅಡಿಷನಲ್ ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಜಡ್ಜಸ್ಗಳು if this person have appealed for the High Court or not. Understood? Then he can give the punishment. Okay, write down that. The appeals from the judgment of Sessions Court and additional Sessions Court lie to the High Court, comma, if the imprisonment is more than 7 years. If the imprisonment is more than 7 years, full stop. The death sentence or capital punishment given by the Sessions Court or additional Sessions Court should be confirmed by the High Court before it can be executed, comma, whether there is an appeal by the convicted person or not. Okay, what does this criminal matter says? ಏನ್ ಹೇಳುತ್ತೆ? What you have written now?
If the imprisonment is more than 7 years, the death sentence was given by the Session Court or additional Session Court, the person can appeal to High Court.
And see, the imprisonment can be given by Sessions Court or additional Session Court for criminal matters, not for civil matters. If they are also having the right to give the death punishment, but they should cross check whether this convicted person have approached for the High Court or not in terms of appealing. Okay, before the execution of that. Next comes the supervisory jurisdiction. Supervisory jurisdiction. Supervising of all the courts, district courts and tribunals. Just write down. A High Court has the power. Superintendence of all the courts. Superintendence of all the courts and tribunal courts that is working in its territorial jurisdiction. Okay, next they have written the court of record and also the power of judicial review. The same here as well. Okay, other definition same ಏನಿದೆ ಅಲ್ಲೂ ಕೂಡ ಇದೆ. Okay, just write down only the title of that. Code of record, code of record, code of record. Then power of judicial review, power of judicial review. Full stop. Full stop. Last one, control over subordinate courts. Control over subordinate courts. See, the subordinate court means lower courts, that is district courts. For appointment of district judge, for promotion, for transferring of district judge, that is by the high court. That is consultation of governor is required. Okay, and also additionally the other district judges as well. Judicial services nalli bere district judge ida. Okay, that all. Next. It can withdraw a case pending in the subordinate court, that is district court. District court nalli yavadru case pending ittu andre it can get transferred. It can take that case. Whatever the judgment that is given by the high court, that is binding on lower courts. ನಮ್ಮ ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಏನಾದ್ರೂ ಒಂದು ತೀರ್ಪು ನೀಡ್ತು ಅಂದ್ರೆ that is binding on all the district courts. Is there any doubt still now? No doubts. Okay. And now we'll study regarding the common high courts. Common high courts. Just put the heading high courts in Karnataka, sorry, high courts in India. High courts in India. Okay. There are 25 high courts in India. Allahabad High Court. This is not important when it was been established. You only need territorial jurisdiction. That's it. Allahabad High Court, that is situated where? Uttar Pradesh. Uttar Pradesh is having Allahabad High Court. Next comes Andhra Pradesh High Court, that is only for Andhra Pradesh. Capital Amravati. Okay, Allida. In 2019, it was been established. Andhra Pradesh, Telangana was been formed. Andhra Pradesh was been split into two states. One is Andhra, another one is Telangana. In 2014, in 2019, Andhra Pradesh have set up one of the High Court for itself. Next comes Bombay High Court. Very important. Bombay High Court. This is a common High Court for which Bombay is in where? Bombay is in Maharashtra. Along with that, the union territories like Dadra and Nagar Haveli, Daman and Diu, along with Goa. Okay, all the Goa people, Daman and Diu, Dadra and Nagar Haveli people can appeal for Bombay High Court. In Goa, there is no High Court because Goa's population is less in number. ಎಲ್ಲಿ ಜಾಸ್ತಿ ಪಾಪ್ಯುಲೇಷನ್ ಇರ್ತದೋ ಅಲ್ಲೇ ಹೈ ಕೋರ್ಟ್ಗಳು ಜಾಸ್ತಿ ಸೆಟಪ್ ಮಾಡೋದು. Lesser population, that territory will be merged with the states. ಬರೀ 5,000 10,000 ಇರುವಂತ ಯೂನಿಯನ್ ಟೆರಿಟರೀಸ್ ಅಲ್ಲಿ there is no requirement of high courts. ಅದೆಲ್ಲ ಫಂಕ್ಷನ್ ಅದೆಲ್ಲ ಮಾಡ್ಬೇಕಲ್ಲ, ಇಟ್ ಟೇಕ್ಸ್ ಹ್ಯೂಜ್ ಬಜೆಟ್ ಫಾರ್ ರನ್ನಿಂಗ್ ದ ಹೈ ಕೋರ್ಟ್ಸ್. ಅದಕ್ಕೆ ಏನಂದ್ರೆ ಫಾರ್ 5,000 10,000 ಪೀಪಲ್ ರಿಸೈಡಿಂಗ್ ಇನ್ ಯೂನಿಯನ್ ಟೆರಿಟರೀಸ್ ಅದನ್ನೇ ಮರ್ಜ್ ಮಾಡ್ಬಿಡ್ತಾರೆ for the other high courts. The same way, Kolkata High Court, very important. West Bengal, Andaman and Nicobar. Andaman and Nicobar Island is in Bay of Bengal. There is a West Bengal. Adike Andaman and Nicobar Island is merged there. Next, Chhattisgarh High Court. Okay, Chhattisgarh High Court, that is for Punjab and Haryana. For Punjab and Haryana, it is a common High Court. That is Chhattisgarh High Court. Sorry, it is Chhattisgarh. Okay, this is the state. I just got confusion. This is Chhattisgarh. This is a state. It is having. Next, Delhi High Court. It is in Delhi. It is the only one union territory that is having its High Court. All the rest 7 union territories have been merged with one another. Next comes Guwahati High Court. Guwahati is in Assam. Assam, Nagaland, Mizoram and Arunachal Pradesh. All these 4 states are having one common High Court. That is Guwahati High Court. Understood? All these 4 states, whichever people are residing in these 4 states, they should approach Guwahati High Court itself. Next comes Gujarat High Court. That is Gujarat. Himachal Pradesh High Court, Himachal Pradesh. Jammu and Kashmir High Court, Jammu and Kashmir, one union territory, Ladakh is another union territory. Next comes Jharkhand, Karnataka High Court, that is in Bangalore. There are different benches. It is in Dharwad and in Gulbarga. Next, Kerala High Court. Kerala, Lakshadweep and Kerala. Kerala is this side, that is west side. Lakshadweep is also in west side. Okay. Next, Madhya Pradesh High Court, Madhya Pradesh. Madras, Tamil Nadu and Pondicherry. Puducherry. The Puducherry is situated in Tamil Nadu itself. That union territory along with the Tamil Nadu, it is common High Court. It is Madras High Court. That is in Chennai. You know the bench, that bench is in Madurai. Extra High Court tara. Bench means extra High Court. Next, Manipur, Meghalaya, Odisha, Patna High Court. Patna is capital of Bihar. Next, Punjab and Haryana High Court. Punjab, Haryana, Chhattisgarh, Chandigarh. Okay, Chandigarh High Court anta karitare adna. Okay, Chandigarh is a union territory. For that, the 2 states plus along with union territory, that is merged. Rajasthan High Court, Sikkim High Court, Telangana High Court. Telangana High Court is in Hyderabad. Next, Tripura High Court, Uttarakhand High Court. Okay, which are the common High Courts? Bombay High Court, Kolkata High Court. Okay, Kolkata High Court. Next, Guwahati Jammu and Kashmir, Kerala High Court, Madras High Court, Punjab and Haryana High Court. These are merged. Totally, there are 25 high courts in India. Understood? Just write down only the merged high courts, common high courts. Don't write the other one. Only write down the common high courts. Okay. Start with Bombay. Let me mark. You just start with that. Bombay High Court. Next, Kolkata, Guwahati, Jammu and Kashmir, Kerala, Madras. 6. Frequently asked question in your prelims. Next, write down this. Punjab and Haryana High Court. Last, Punjab and Haryana High Court. Punjab, Haryana and Chandigarh. Finish. What is this bench High Court? You have already seen there. Bench and third. In Karnataka, we are having 2 benches. One is in Dharwad, another one is in Kalburgi. Why they are established? Even though we are having Bangalore High Court, why these other benches have been formed? Yes, it is easily accessible for the people of local nearby. The same Bangalore ಹತ್ರ ಇರೋರು ಬ್ಯಾಂಗ್ಳೂರ್ ಹೈಕೋರ್ಟ್ಗೆ ಅಪ್ರೋಚ್ ಮಾಡ್ತಾರೆ, ಆರ್ ಎಲ್ಸ್ ನಿಯರ್ ಬೈ ಫಾರ್ ಧಾರವಾಡ ಫಾರ್ ಕಲಬುರ್ಗಿ. ಇಟ್ಸ್ ಲೈಕ್ ದಟ್, ಈಸಿಲಿ ಆಕ್ಸೆಸಿಬಲ್ ಆಗ್ಲಿಕ್ಕೆ. ಅಂಡ್ ಟು ಕೇಸ್ ಲೋಡ್ಸ್, okay, to reduce the case loads, that is Bangalore High Court can't solve all the cases. It will advise for the other judges bench to solve the cases. CJH, there will be only one CJH, Chief Justice of High Court. There will be other judges in a High Court. Okay. Only one Chief Justice of High Court will be there. There were different and n number of High Court judges are there. Okay, allinu irtare. Okay, and CJH, Chief Justice of High Court, can assign the cases for this specific person or for that specific place. Okay, ಈ ಕೇಸ್ ಅಲ್ಲಿ ಹ್ಯಾಂಡಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹಾಕ್ಬೋದು, ಹೋಗಲ್ಲ. ಓಕೆ, ಅಲ್ಲಿನೂ ಇರ್ತಾರಲ್ಲ ಫಿಕ್ಸ್ 3 to 4 members will be there in Dharwad, 3 to 4 members in Kalburgi. ಅಂಡರ್ಸ್ಟುಡ್? ಅಲ್ಲಿ ಫಿಕ್ಸ್ ಅವ್ರು ಡೈಲಿ ಅಲ್ಲೇ ಇರ್ತಾರೆ. ಟ್ರಾನ್ಸ್ಫರಿಂಗ್ ಆಗ್ತಾ ಇರುತ್ತೆ. ಓಕೆ, ಟ್ರಾನ್ಸ್ಫರಿಂಗ್ ಫ್ರಮ್ ಒನ್ ಹೈಕೋರ್ಟ್, ಫ್ರಮ್ ಒನ್ ಬೆಂಚ್ ಇಂದ. And who will establish this bench of High Court is President of India on recommendation of Union government. Central government recommendation beko. Then the President of India will establish the benches in specific places. Consultation yaar beko? Chief Justice of India along with the state government. If the state government tells that more number of cases are there in High Court, they will recommend for the Chief Justice of India. And Chief Justice of India will recommend for the Parliament. Parliament will decide, then President will establish that. It's having huge process. Okay. Finally, establishing will be made by the President itself. But in the held firstly the state government, then the CJI, Chief Justice of India. Then Chief Justice of India will give the recommendation for the Union government, that is central government, Parliament. ಹೇಳ್ತದೆ ಅಲ್ಲಿ ಅವಶ್ಯಕತೆ ಇದೆ ಅಂತ ಬೆಂಚಸ್ಗಳು ಅಂತ ಹೇಳಿ. Then they will request for the President for establishing the benches at the High Court. We have completed the High Court chapter. Okay. What we have studied in High Court chapter? Are there any fixed number of High Court judges in India? No, it depends on the workload. Who is having the right to appoint the High Court judges? President is having the right to appoint the High Court judges. What are the qualifications? He should be a citizen of India. At least he should hold office of judicial service for 10 years or else advocate for 10 years. Okay. Then the High Court judges can give the resignation for whom? President. Oath. Removal. President. What is the removal procedure? Can I tell you? Can you tell me? First, removal motion should be passed in either house of parliament. Okay. In Lok Sabha, how many members should sign? Rajya Sabha, 50 members. Then it will be sent for the speaker or chairman. They are having the right to accept or reject that motion. If they accept, they will establish 3-member committee. Who will be there in 3-member committee? Chief Justice of India or Judge of Supreme Court. Then Chief Justice of High Court. Next, distinguished jurist. Okay. If that person is if the person is guilty, then it should be passed in a parliament in both the houses with the help of special majority through the voting. When it is passed in Lok Sabha and Rajya Sabha, it will be sent for the president. Now president should remove that person. President can't deny. Understood? President can't withhold. Sign ಮಾಡಬೇಕು ಅವ್ರನ್ನ ರಿಮೂವ್ ಮಾಡಲೇಬೇಕು. Okay. And then what is the maximum age for retirement? 62. For Supreme Court judges, it is 65. Okay. And which are the jurisdiction and powers of the High Court? Already we have studied. Original jurisdiction, appellate jurisdiction. Next, supervisory jurisdiction. Next, writ jurisdiction. Next, court of record, judicial review. Last one, supervisory jurisdiction, as I told you. Okay. And control of subordinate courts. How many high courts are there? 25 high courts. Which are the common high courts? Bombay High Court. Under that, which are the jurisdiction? Maharashtra, Goa. Both are 2 states. Next comes the Union Territory. That is Daman and Diu, Dadra and Nagar Haveli. Ishtella ಸೇರಿದ್ರೆ ಒಂದು ಬಾಂಬೆ ಹೈಕೋರ್ಟ್. ನೆಕ್ಸ್ಟ್ ಕೇರಳ ಹೈಕೋರ್ಟ್, ಕೇರಳ ಅಂಡ್ ಲಕ್ಷದ್ವೀಪ್. ವೆಸ್ಟ್ ಬೆಂಗಾಲ್, Kolkata High Court, West Bengal and Andaman Nicobar. Okay. Next, Chandigarh High Court, Punjab, Haryana, Chandigarh. Jammu and Kashmir High Court, Jammu and Kashmir and Ladakh. Okay. Which is that union territory that is having single high court? Delhi. Delhi is having both Supreme Court as well as High Court. Okay. Is there any doubt still now? We have completed the High Court chapter as well. Okay. Tomorrow we'll deal with the local bodies. Sorry. Tomorrow we'll deal with the Parliament chapter. Okay. Parliament and state government. Then Panchayats. Let's wind up the class.